My lord, my daughter has been missing since last 2 months, madam.
Please pass on the memo. I will definitely consider.
May I
This case, in this case,
Please pass up. Don't worry. We'll sit. We'll take.
I prefer.
Your Lordship, may I please, Your Lordship?
I beg your pardon, my lord.
Your Lordship, there.
From the list, my lord. Here in this, a contempt application is there. It is staring at us. This WA relates to grant of 5 advance increments to the
We'll
estate
take up.
officer.
Don't worry.
It requires a little bit of hearing.
Yes, let us see.
Your Lordship, one urgent mentioning, if I may be permitted, Your Lordship. Your
Yes.
Lordship, there is a writ petition which was listed before the Honorable Acting Chief Justice 6 times but could not be taken up. I am seeking against the respondent GST authority. If the Your Lordship consider it to be taken up tomorrow, I have already submitted the mention note as well.
Let us see. Let us see, sir. Every matter is important to us. We will definitely take up.
I'm sorry for your lordship's indulgence. This item 23, which my lordship is mentioning, but it has huge financial ramifications because the learned single judge has directed for payment of 5
We'll take up. We'll take up. Don't
because the
worry.
contempt is posted tomorrow.
Don't worry. We'll take up.
Anytime convenient.
Yes, yes, sure. Yes.
Supplementary list, fresh admission, item number 1.
So after the lordship is already there before.
Yes.
Kindly
remember my friend.
See, there is no date in the judgment regarding from which date which service or petitioner's husband service to be regularized. The lordship only that clarification.
When the
Of that,
You can go before the single bench seeking a clarification or a modification of an order. For that, the appeal has to be. I read the brief yesterday evening, so I just found that only grievance, because all the release have been granted to you. They have not challenged that order.
No.
So they have accepted this. Only thing is that you wanted a particular retrospective date to be given.
There is no date there.
You wanted, sir. That's a
Notionally,
English word. I use it. You wanted the date to be given from a retrospective date. Particular date that from which this day it will be deemed to have been regularized for the purpose of computation of a qualifying service for pension.
Yes.
True. So you have the single bench, sir, for modification and clarification of an order. You could invite the attention because the learned judge who has applied its mind is aware that what he has done.
Also, we want the notionally
This is a state's appeal.
Yes.
You are?
Correspondent, my lord.
Let me please.
Sorry, I was under that impression that you have challenged the order.
Let me.
No.
Let me please.
Don't hijack his right to begin. Under Order 18 Rule 1, he has a right to begin.
3 days back only this matter was there with your lordship. Your lordship wanted my learned friend to file an affidavit stating that he will be satisfied with the notional benefits.
Now you have seen Justice Nath's judgment of the Supreme Court, and there are subsequent judgment also which says that if he has worked for a considerable period of time, then at least some kind of a solace.
That day your lordship said all these things. And
now there has been a little bit departure.
And friend is required to file an affidavit. Today he has given it.
From the day when he joined.
He wanted.
Yes.
But on the last occasion, if your lordship remembers, my learned friend said that he will be satisfied if notional benefit is given to him.
It's notional benefit. We want notional benefit only for the purpose
only for the purpose of family pension.
Yes.
I find that he died within 1 month.
After retirement within 1 month.
That is what I say. He retired in January and died in February.
Yes. Lordship passed that order. If your lordship passed that order, what your lordship was opined that day.
Brother, let us pause. Where is the judgment? Impugned hearing, certified copy. Annexure 5. Yes. This appeal is at the behest of the state, assailing an order, judgment and order dated 1844. Part WP within bracket C number 32104 of 2023, by which the prayer for extending the benefit upon regularization of the service was allowed in the following. Then please quote the last paragraph, that is paragraph 6.1. The genesis of the dispute can be traced from the fact that the husband of the respondent was initially as an Ayurvedic compounder slash pharmacist on ad hoc basis.
As against reserve.
On ad hoc basis, on and from 8/5/19. 87. But he joined the said post on 13/5/1987 as would be on the service book prepared by the authorities. Indubitably, the next paragraph. Indubitably, the husband of the respondent continued to discharge his duty from the date he joined the service, but such services was not regularized. And after attaining the age of superannuation, he was not extended the benefit of the retirement benefits. Now, retirement dues. Unfortunately, the said employee died within 1 month after the date of attaining superannuation. Stop. The respondent approached the authorities for family pension as admissible in the statutory rules, but the same was not attended to by the authorities, which constrained the respondent to file a writ petition, being WPC number 660 of 2023. Stop. While disposing of this writ petition, the direction was passed upon the authority to take a decision on the claim of the respondent. But the authorities did not find any material to regularize the service of the husband of the respondent, and proceeded to reject the said application. The order of rejection for the aliens in the writ petition, and a plea was taken by the appellant that the husband of the respondent was appointed against a reserve vacancy, which was never filled up by taking a due selection process till he attained the age of superannuation. It was thus submitted that such ad hoc appointee is not in to get his services regularized, and therefore there is no infirmity and or illegality in the order of the authority in rejecting the prayer of the respondent. Next paragraph. On the backdrop of the aforesaid undisputed facts, the single bench proceeded to decide the claim of the respondent and took into account the judgment of the Supreme Court rendered in case of the state of Gujarat and others versus Talshibhat Dhanjibhai Patel, reported in 2022 live law within bracket SC7, Amarkanta Rai versus the state of Bihar and others, reported in 2015 SCC online SC 214. And held that the employee who might have been appointed on ad hoc basis but rendered the services for a pretty long time without any intervention of the court should not be treated indifferently, but as a model employer, the state being a welfare state must take a pragmatic view. Even in case of a state of Secretary State of Karnataka versus Umadevi within bracket 3, reported in 2006, volume 4, page SCC page 1. The next court, the Constitution bench of the Supreme Court, in unequivocal term held that the welfare state must take an initiative of formulating a one-time measures to regularize the irregular appointees who have worked 10 years from the date of the said judgment without any interim order passed by the court. And the benefits should also be extended. The judgment of the apex court was taken into consideration in a subsequent judgment rendered in Talsibhai Dhanjibhai Patel within bracket Supra, wherein it is held that even if the ad hoc appointee is entitled to the benefits if he has rendered services for a considerable period of time and as a welfare state, the benefit of the pension cannot be denied. Next one. In Amarkanta Rai within bracket Supra, the apex court, on taking all the relevant factors, held that once the state has allowed the ad hoc appointee to render services for a considerable period of time, without any break or discontinuance, it would be the injustice that would be perpetrated upon such ad hoc appointees if their services are not regularized. Stop. The law as enunciated herein above leaves no ambiguity in our mind that the husband of the respondent, though appointed on an ad hoc basis, on a reserve post, but till he attained the age of superannuation, he was allowed to render services, as there was no attempt made by the state to make a regular appointment to the said post. The technicalities should not overshadow the substantial justice. The moment the technicalities is pitted against the substantial justice, the latter must prevail. Precisely taking into account the aforesaid proposition of law laid down in the above noted reports, the single bench directed the retired dues, directed the regularization of the service of the deceased employee, and extend the benefit of the family pension to the respondent herein. Stop. However, a plea is taken by the respondent that though the substantial relief has already been granted to the respondent, but the single bench did not indicate the date from which the same shall be deemed to have been regularized. Stop. Though the respondent has not taken out any cross objection, nor has approached the judge for a clarification and modification, yet taking into an account and to render the complete justice to the litigant, we do not find any impediment in acceding to such prayer as the of a qualifying service is a determinant factor for quantifying the family pension to the wife of the deceased employee. In view of the law as above, we do not find there is any infirmity in the ultimate decision taken by the single bench. Stop. However, we modify the penultimate. We modify the said judgment and order to the effect that the deceased husband of the respondent shall be deemed to be in service at the substantive post from the date of the joining, and such service shall be considered as the regular appointees on the said post, entitled to all the benefits attributable to the said post at the time of the superannuation. The respondent, however, fairly concedes before the court that she has abundant she has abundance, acquiesced, waive her right to get the retirement benefit of the husband admissible on the date of the superannuation and restrict her claim to a family pension. Stop. In view of such categorical stand having taken before us, the judgment and order is modified to the extent that for the purpose of computation of the qualifying period of service, the same shall reckon from 13/5/1987, and since the deceased employee debit the office on 31st January 2023, such period would be taken into account for the purpose of ascertaining the quantum of the family pension. To that except to the extent as above, the appeal is disposed of. Connected applications are also disposed of.
Only one line, my lord, which had one round, your lordship have not dealt with that.
That is what is I can find from the judgment.
Sorry, my lord.
I was just looking at the judgment, sir. I was not going into any other document.
In that direction, by creating a supernumerary post, you
That is not
regular.
that is not that extent. Is not required.
Yeah,
we have said that it will be deemed to reckon from the date, so no supernumerary post.
Mostly.
And after the death or a retirement, can you create a supernumerary?
No.
He said on the substantive post he rendered service.
Your lordship said.
Only one minor actual one.
Yes.
Listeners, forget
Still unsatisfied, sir.
that I am not this that factual person husband has read application that during his present that was the representation directions. Yeah,
Whatever.
that may be.
It makes hardly any difference. Don't worry.
Item number 2.
Very fair, that I must appreciate.
Yes. Yes.
Against the judgment of the Honorable Single Judge.
Where is the judgment, sir?
Annexure 5.
Fine. Oh, this is a case of I do not know what is the expression used, land.
Yes, with the land, under the land outstay.
Outstay. We use the word land losers. I think the Supreme Court uses the word land losers.
But here, they, the circular, they have used.
I do not know outstay.
They have used house. The fact.
That is what I say.
There is a policy.
Of giving an appointment. Your grandson, I mean, from a daughter's side,
Yes.
he was given an appointment.
He's not eligible.
And then they took a decision in the meeting and say that no, he is not eligible because the criteria is only 3 categories.
Yes.
Unmarried daughter is there. So there was a married daughter, so you are not entitled. The son was entitled, but he was already in jobs. I have read that. So what is your grimace? If the scheme is restricted, then can we rewrite the scheme?
No wonder, I'm just.
Show us that the son of a married daughter
Yes.
comes within the purview of this scheme. That's the only thing, nothing more than
It is not in the scheme. It doesn't come within the purview of the scheme. Married daughter's son doesn't come within the purview.
Oh, you have come.
Yes.
Oh, then, sir,
My lord, in this case,
sir,
my argument for the Honorable Single Court was threefold, my lord. Number one, my lord, on my part, there was no fraud or misstatement or misrepresentation. So there was no fault on my part. I was inducted into the service on being nominated by.
that argument is valid argument in case of a their decision to recover the excess amount paid to
My
you.
lord, I have relied two Supreme Court decisions where it says that once a person who has been inducted without any practice of fraud or misrepresentation, my lord, he should not be terminated. That is my part.
Without following the process.
Second argument was, my lord, that term family, that was an inclusive definition. That definition starts with the term include, and the definition is always enumerative. To that extent also, I had relied a apex court decision which says that the inclusive definition is always enumerative.
My judgments are also there.
My lord.
When a definition clause, there are two ways. One is means and includes.
Oblige, my lord. Yes,
One
my lord.
is only means
and
one is only includes.
that is
So the moment the word includes are used, it gives an expansive definition of this. But does not mean that it will engulf each and every concept within it.
my lord, my humble submission is that they have extended that inclusive definition and given employment to daughters, sons also. That is annexer.
Where is that?
My lord, that is annexer 15 to my rejoinder. Your lordship may see.
Shows that they have included the daughter's son. That's matter ends there.
My lord, your
Then
lordship
they have
may-
nothing.
Your lordship may see the rejoinder filed to my writ application.
Writ. Oh, go to the writ. That clinches an issue, sir. I asked him very simple.
Annexer
Sure.
15 series, my lord.
Yes.
It's the annexer to my rejoinder, my lord.
Correct. Oh, they have given it to
Your
son-in-laws.
Son-in-law,
Oh, daughter's son last.
daughter's
Who
son,
is this?
daughter's son.
Somebody else.
My lord.
It is somebody else.
It is somebody else. Through RTI, my lord, I have obtained this instruction that they have given.
It is a case where there is no son or children. There is no son, some son is not available.
Sir. Then I have some queries to you,
Your
sir.
lordship may kindly see.
I have some queries to you.
Yes, sir.
If the scheme contemplates that who are in the purview of this,
Yes, my lord.
then you cannot travel beyond it.
Yes.
The moment you traveled beyond it and perceived that this is also included,
No, we are never included in this case.
the daughter's son, then you cannot take a plea that it is controlled or brindled by some conditions, that in the event there is no son, in the event there is no son's son, in the event there is no other person except this, then and then I can give. These conditions you cannot artificially impute
No,
into it.
here-
You have to be very uniform.
Here, my lord, son is available.
Sir, I'm again saying, can you put an artificial distinction or restrictions?
No, we cannot put an admission.
Beholds the scheme. The scheme does not contemplate that.
No, it is the government scheme, my lord, so not my scheme.
No. Government scheme, what I find is only the son and an unmarried daughter you have included.
No, my lord. Further, the guidelines regarding rehabilitation assistance, the term family has been defined to include husband, wife, and unmarried children.
Yes.
Therefore, the question of family of a married daughter being eligible for employment under rehabilitation scheme doesn't arise. That is the government scheme clarified.
I have held otherwise there that you cannot exclude the married daughter. You can't make a classification within the homogeneous class. I have heard it's against the constitutional mandate. You can't restrict it to unmarried. Why? That there the scheme was the same, unmarried. I said this is unconstitutional. You can't create a class within the homogeneous class unless there is an intelligible difference here. You can't do it. How can you rationalize it? The daughter is a daughter, whether a married or unmarried. It makes hardly any difference.
80 years of service I was told now.
Because it is the policy which says you have to give to the
The policy must withstand on the anvil of a constitutional mandate. Frame a policy which offends the core value of the Constitution of
The
India.
state government's policy we are implementing.
How can you do it?
We are
It says that you cannot make a class on the basis of a gender, on the basis of a caste, on the basis of
that
a
I
card.
understand.
Now, question is, when you create that unmarried daughter will stand on a different footing than the married daughter, that is unreasonable. And when you have already included the daughter's son in title, that's the page he is referring. That's why I'm putting a question to you, sir.
Doctor's son.
Yes, please come to Annexure 15 series of their rejoinder. Please come, just, do you have the copy?
Oh, no, I have got this.
Please see the last. You have said late Bhaskar Sahu, the Dilip Sahu, son of Kamini Sahu, and then the relation with the land oustee is the daughter's son.
Maybe a case where there is no son.
Sir, again I'm saying, can you create an artificial distinction?
It will be a case of negative equality.
It is not a negative equality. No, sir. It is not. You are creating a negative, the disparity, I would say, not
We have
equality.
created
Disparity.
this government's policy we are bound to implement. That is
There is nothing in the government's policy, sir. Show us that the daughter's son is included.
You're not in the
From the family simply says, as you read,
the government policy I find.
please, family means then,
They have explained your lordship, page 28.
please what, read that.
Yes. Further, the guidelines of rehabilitation assistance, the term family has been defined to include husband, wife, and
That you read.
unmarried children.
Correct.
Therefore, the question of family of a married daughter
Does not arise.
being eligible for employment under the rehabilitation assistance doesn't arise.
Correct. Then, thereafter, tell me.
So that-
Mr. Das.
It's silent then. What about that daughter's son? I'm just talking. What about daughter's son? If it is restricted to unmarried children, then either the son must be unmarried or the daughter must be unmarried. Correct? If you can't extend it,
No,
normally, ordinarily, there cannot be a grandchildren from an unmarried son or unmarried daughter.
no, it cannot be. That is right.
So it is impliedly excluded. Then how you have given a daughter's son here? He holds the policy.
Mr. Das, this court under Odisha Civil Service Rehabilitation Assistance, Mr. Haripad Mahanti knows it. Justice Sadagi has struck down that word. Said that unmarried daughter, which is prefixed to daughter, is to be ignored or omitted. Isn't it? Both married and unmarried. For following
You have, then you can't justify. Sir.
Under the RPDSC, under the chairmanship collector, your lordship, I kindly turn to page 24 of my brief.
What?
Said, inviting reference to the subject cited above, I am to inform you that Sri Loknath Pradhan, son of Gumani Pradhan, has filed grievance petition praying for early consideration from job rehabilitation. Sri Dabur Pradhan, the RT awardee, was lost agricultural land, homestead land, dwelling house in village Baluga, Kamas, so and so village coming under RR policy 89. Dabur Pradhan has one married son, namely Gumani Pradhan, and married daughter, namely Pramila Pradhan. Gumani Pradhan constitutes a separate family as on date, village Baluga Kamari. and eligible rehabilitation benefit. Accordingly, Lokanath Pradhan, son of Gumani Pradhan, was postponed for providing job realization against the policy. One job to one family. Subsequent case has been duly vetted by you and approved by the underside. It is also accepted that one job has been provided to Jayanta Pradhan, son of Pramila Pradhan, who is the married daughter of the recorded tenant. Providing job rehabilitation, son of married daughter is not coming under the nomination criteria.
Yeah, absolutely. I am with you. Explain this. Rejoinder, Right to Information Act, and to a Bhaskar sir. Please explain.
That
I appreciate what you say, accept it. What is your explanation to Bhaskar sir?
let me just
Show him the document.
Let me take note. The document will maybe with me. I will take instruction or to make it.
No, you have not seen that. That's why I'm saying, please, can you show him why we are referring so vociferously is this last item, Bhaskar, last column.
Such places where some sons.
Again, sir, that the question would be, in absence of any clear indication in the scheme or in any clarificatory note, can an authority of its own make a line of distinction?
No, RPDSC might have recommended that.
Sir, again, recommendation deholds the policy because can you visualize the situation?
That I understand.
Under the public employment, Article 16, everybody should get an equal opportunity.
Yes, equal.
You are appointing the person without making a white publication, without doing anything. I am just talking about the Viseswara Rao's judgment of the Supreme Court as well. Just reminding you.
His land. We have acquired his land.
Sir, please consider. You have not adopted those procedures which is required under the Constitution.
Yes.
The exceptions are, there are two exceptions. One is relation to a compassionate appointment and one is relation to a beneficial piece of scheme legislature.
That is it.
These are two exceptions. You did not have to follow those rigor of the recruitments while appointment. Technically, it offends Article 14 and 16, both. But since it is a welfare piece of scheme, so it is always respected. Now, when you have formulated a welfare scheme, then you should restrict within the peripheral of the scheme.
That scheme.
Right? Now it appears that you are transgressing and you have transgressed. Now the justification you are trying to give to the court, look, yes, I have, but there was this special circumstances. Then the first question is, if the scheme does not permit you to do,
could not have been given.
If you have done it,
I concede, could not have been given.
Why? Have you taken any steps like him for his removal?
The whole difficulty when state recommends, that is not the problem.
Can't.
That is the whole difficulty.
No.
And in the subcommittee meeting, which my learned senior.
And he was recommended. He was appointed. He rendered services for a pretty long time. One fine morning, you sat, say, no, I will not. Sir, I don't.
Yes,
you are a model employer. Once you have done somebody, then you should also do the same thing.
All right. No, in fact, to be fair with this honorable court, I had given my opinion written in.
That is what has to be done.
That may not be reflected in the judgment.
I have delivered a lot of judgments on this, so I do not want to repeat it again. Yes.
When the RPDSC
Dismiss.
headed by collector recommends you remove.
My submission, RPDSC never recommended for removal. He says take action against your officer. That is the language.
But why? You have felt the pulse.
Item number 3.
Not mention on the Odisha Entry Tax Act. Notes, I'll take a lordships to the date chart list of dates. Note in 2006, there was an intelligence report made by the intelligence authorities. That intelligence report was termed as an audit visit report by the assessing authority. And he initiated assessment. A demand was raised. I filed an appeal against the order. And the appellate authority decided that that intelligence report cannot be subject matter of an audit visit assessment. It can at best be an assessment under section 10. I'll read that portion of that first appellate authority.
You have three kinds of assessment. One is three kinds of assessment.
My lords.
One is self-assessment. Second is audit assessment by the department.
And then is escape assessment.
Audit is undertaken by the department.
By the department.
The third one is on the basis assessment taken on the basis of intelligence report, that is third party.
So it was. The lordships turn to page 47, my lords.
So here the third party's report was treated to be audit report.
To be an audit visit.
And department construed it to be audit report and proceeded with audit assessment.
Proceeded with an audit assessment. They did not share the audit visit report, intelligence report to me. They only confronted it, part of it. And then an assessment was made. I challenged it in first appeal. The first appellate authority said that it cannot be an audit visit assessment. It has to be maximum an assessment under section 10. That is reassessment or assessment of escape turnover. So he matter where he said at page 48, my lords, with the above facts and circumstances of the case and without delving further into the factual disputes involved,
48.
This forum set aside the impugned assessment order passed by the learned assessing authority for the material period with a direction to initiate proper proceedings strictly in accordance with the provisions of the OET Act and rules made thereon. Now, then he issues a notice, which is at page 49, for set aside assessment in pursuance to the appeal order. Then I filed my reply where I stated that a proceeding under section 10 is already barred by legislation.
What? That is there because it was only here that so far as the decision on the basis of this particular the report and treating it as an audit report that offends the provisions contained in the OET Act. And it was set aside. But they say that you can proceed under the provisions of the law. No difficulty. Then there cannot be any illegality in this regard. And now the limitation has intervened. Let us see.
My lord, I find a reply stating that limitation has crept up.
The ingredients they have followed.
My lords,
After first appellate,
give me just one more.
Where is the act?
Both the anti-tax and that both acts are necessary.
My lords, once a investigation thing and I took part in the assessment, then it said that as per section 49 of the Odisha Value Added Tax Act, which is a parametric thing, this limitation will not apply. I'll read out that portion, my lords, 49(2) of the Odisha Value Added Tax Act.
No, first thing is that it is under section 10.
My lords.
Correct. So the period of limitation is 7 years.
My lords.
7 years from the date of the
End of the
year
My lords.
computation of the period for the tax for the year.
This is the assessment
So
year
this is
2005-06.
what is given. And what is this value added tax?
My lords, value added tax limits. He said 40. This limitation will not apply because
40.
9 too much.
Forty-eight.
49.
49 too.
48, subsection 2.
So it reached the first
Oh,
appellate
this is
authority.
the extended period of 5 years.
It treats the first appellate authority as a court or a tribunal.
Exclusion is like section 14.
Not first appellate. First appellate are flexible.
Not specifically, it relates to a court or a tribunal. It treats the first appellate constitutional authority as a
Then
tribunal.
48.
48.
Hello?
48.
No, it was in the other like the limitation that you will. That if there was already a stay passed by the court, competent court, then that period would be exclusive for the purpose of the computation. Like it's section 15 of the Limitation Act.
Judgments. Multiple judgments are there. I'm sorry, I have no judgment. First appellate authority is a court.
You say there is a multiple judgment and say, sorry, you have no judgment. What does it mean?
Parthasarathi is final authority of that. Parthasarathi is. Honorable Supreme Court.
I have to take 1 day accommodation to produce all the judgments. So perhaps that first appellate authority, under Income Tax Act, there are many judgments. First appellate authority is a court.
Court of limited jurisdiction, sir.
Your Lordship,
That
here,
cannot be court.
Then when the proceedings,
Under the limitation.
then when the proceedings were going on,
Injunction and all everything. Section 15. It is borrowed from it.
look, then when the proceedings were going on, this honorable court delivered a judgment in case of
Just let me understand, because this is a local act here, which has been borrowed. Is there any definition of a court given?
no ballots. Under the act,
In the
it has
act.
not been given.
Tribunal is given. Tribunal is given.
Tribunal has been given.
No difficulty. So the court is not defined here.
No ballots.
Let us see the judgment. Let us see. Prima facie, we find some arguable case has been made out for that.
Your Lordship,
The period under section 49 or a 48,
Your Lordship.
then one has to understand that what should be the meaning assigned to a court.
Ballots. Thereafter, what happens, ballots? When the proceeding was going on, your lordship delivered a judgment as for the provisions of section 10 assessments, where your lordships held that there has to be a prior assessment before initiation of proceedings under section 10, and that order has to be communicated to the assessee. Then section 10 can run. So that judgment before the assessing authority, I said there has been no prior assessment made, and so you should not initiate these proceedings any further. Well, then he passes an order where he scrutinizes my returns and accepts my returns by an order dated 31/3/23. That is almost about 17 years later. That order I challenged before the commissioner. The commissioner says that that is not an order, so the revision is not maintainable. I filed order before him. He again passes an identical order, which the commissioner said that this is not an order and revision is not maintainable, where he forgets to put the date on which it was communicated. I'll take your lordships into that order itself, which is at page 66.
Now the limitation. That is, now he's the.
My notes.
So 10-3,
My notes.
10-3. Instead of 49-2,
My notes.
is it 10-3?
No, my notes. He has said 49.
10-3 of the Anti-Tax Act.
Yes, ma'am.
Here's a that relates to a wife situation. But he has applied 49. All that is assessment has been done. The penalties are further ease of life, fresh life of her.
Single position is done in 3. Same.
It has been limited to 3 years. Yes, 10-3 is also in a similar tune and line of the OET. Is it OET? Yes. Same. There the 5 years, here the 3 years. 10-3. 3.
So from the date of appellate,
Not identical year.
sir, if at all, your argument will be held
Well,
to be correct, that the first appellate authority is also a court.
Well.
So what is the time limit within which you have to?
high BST lordship. 49 to parameter that is.
No. Come to 10-3.
Your lordship.
You have to confine it to 10-3.
Your
Your specific provision is.
Your lordship, where any order passed by the assessing authority in respect of a dealer for any period to be found is found to be erroneous and prejudicial to the interest of revenue.
If it escape, the assessment is also prejudicial to the interest of the revenue.
Your lordship, for a moment, your lordship, what 49.2 says that if the court has set aside the order, which is
Sir, 49.2 is 5 years. 49.2 is 5 years.
The same
10
thing.
is 3 years.
Your lordship, why I am making the
So why
distinction?
you stretch that 49.2 to this
Let me, your lordship,
anti-tax?
let me take the distinction, your lordship. 49.2 saying 49, your lordship, I may be
49.2 has no application to this anti-tax matter.
slowly. I may be permitted to read
Yes.
slowly, your
Yes.
lordship. For my satisfaction, your
Yes.
lordship. Where any court or tribunal passes an order in appeal or revision to the effect that any tax assessed under this Act or the Central Sales Tax Act should have been assessed. Your lordship may kindly give emphasis. Any tax assessed should have been assessed under the provision of law Other than that, under what it has been assessed. Your Lordship, may kindly give the emphasis of these 5 to 10 words. Your Lordship should have been assessed. Other than that, under what it was has been assessed. Then, in consequence of such order, to give effect. Here,
Mr. Kindly appreciate one thing. When you deal with the assessment
Your
or appeal
Your
order under the Entry Tax Act,
Your Lordship,
if the particular statute
Your Lordship,
gives a time period, can you inherit other statutory limitation
Your
into this
Your
and
Lordship,
read into the statute
to my
of entry tax?
my understanding,
This
Your
is,
Lordship,
this is what.
Your Lordship, Rule 34 is there. Rule 34
No.
this mutual supply. Your Lordship.
Sir, no. That is for the purpose of effectuating the statute to the provision. It will
Your
not.
Lordship,
Sir, statute means Entry Tax Act. It is a fact of legislature.
man,
Legislature had, in its wisdom,
Your Lordship,
put 3 years
Your Lordship,
for the purpose of entry tax.
Your Lordship,
Can you read into
Your Lordship,
this 3 years
Your Lordship.
as if it is 5 years, as contemplated on by that? That is the question.
Again, Your Lordship, for a moment, 10.3. 10.3, I think, Your Lordship, it is different. It is just different. Your Lordship, where any order, that there my confusion. I want to clarify my confusion, Your Lordship. Your Lordship, I will be
Sir,
grateful.
each statute has its own
Your Lordship, as for 49.2.
authority to exercise power.
Your Lordship, why I'm giving emphasis to Rule 34, as like as 49.2, there is no such provision under Section 10 or OETR, Your Lordship. Section 10.3 is something, Your Lordship, may kindly.
Sir, please go. I am keeping, then I have to hold a very academic class for that. Let us see both 49. Let us see both 49 and 10.3 to be kept side by side. Let us find out which are used therein. Whether those languages can be reconciled or cannot be reconciled. Let us see. Let us proceed. It says, let us first read the 10.3. It says where any order, it does not make what order, any category or any type of an order passed by the assessing authority. Under what provision is not there? It's an order. In respect of a dealer for a period, for any period, is, then it says that order is found to be erroneous or prejudicial to the interest of a revenue consequent to, or in the light of any judgment or order of any court or a tribunal which has become binding, then notwithstanding, then the non-obstante clause is used, notwithstanding anything contained in the act, the assessing authority may proceed to reassess the tax payable by the dealer in accordance with such judgment any time within a period of 3 years from the date of the judgment. Okay? So what it contemplates is that if any order is passed by the assessing authority, which appears to be erroneous or prejudicial to the interest of the revenue, why it is erroneous and why it is prejudicial to the interest of the revenue of any judgment or the order of the court or a tribunal having found otherwise, which has now become final. Meaning thereby, Section 10.3 will come where an assessing officer passes an order and that order appears to be completely negating the order of the Supreme Court. Supreme Court says this, assessing officer held this, something else. Then it says in such situation, the assessor may continue reassess the tax in the light of the judgment. And for such period, for such 3 years period from the date of the judgment is given. Now the question is, again, I'm saying the difficulty is in the 3 years, in accordance with such judgment or order at any time within a period of 3 years from the date of the judgment and order. I do not know what does it mean by the judgment and order. It is a judgment and order which has already attained a finality, or judgment and order of the assessing officer which is found to be erroneous and prejudicial to the interest. Limitation has to be reckoned from that day. So it is on that basis when the order appears to be contrary to a judgment and an order which has attained finality. 49 CORAMs, it talks about when the order of the tribunal passes in appeal or a revision to the effect that any tax assessed under this act or a central act should be assessed under the provision of law other than the under which it was assessed, other than under which it was assessed. Then, in consequence of such order or order to give effect to the finding and direction of such order. What is such order? Appeal.
Well,
The turnover or income as it relates to such may be assessed or reassessed.
well,
And the case may be to tax at any time within 5 years from the date of such order, notwithstanding the applicability of any period of limitation to such assessment or assessment under this act.
It's a substantive provision.
It is a substance.
Substantive provision.
Your Lordship,
It's a substantive provision.
Your
So
Lordship,
substantive provision.
my Lord, Justice Raman knows very well that judgment being a house. Only difference is that
There's
here
a
the
different
first
context altogether, sir. There's context is that
context is Your Lordship.
something different, sir. I was assisting.
Bad. Your Lordship.
I was assisting
Your Lordship.
standing counsel. I know that.
Your Lordship.
And that
I
very
will,
officer was not
49.
refunding the amount
Here you
amount of 20%. He
Here
was
Your
called to
Lordship,
court.
more appropriate.
My brother,
My Lord, I am his student. My Lord student. Your Lordship, who is simultaneously we were additional student. And much after him, I have engaged as additional study. So I have learned many things from order. Here, let Your Lordship may admit.
very difficult. Very difficult. That's why I say you keep very difficult. You can't borrow something
Sir,
here and there.
Even if
Pick and
we
choose.
accept your argument for a moment that appellate authority is the court or tribunal, whatever,
Only
right? The tribunal is defined that suppose it is court of limited jurisdiction court. So he passed the order on 16/7/2019. You invoked after you have invoked the provision after for reassessment.
Your Lordship.
You have invoked that provision after 3 years. 10-3 already barred.
We can 5 years. I admit.
No, 5 you cannot. 3.
No, that is, he says that the multinational, I will again file.
It has been done.
That is what I am saying, that that's why they read the word. Absolutely different.
Your Lordship,
Sir,
I admit.
sir, you have a-
I'll examine. I'll examine. I may have.
No, only one issue you have to, other than the law.
Your Lordship.
This is the word which is used in 49(2) has to be understood in that.
Exactly. I'm pressing only that. I'm pressing only that. I'm trying to distinguish 10(3) and 49(2) only basing on that because it has been assessed 9C and the appellate authority has said that it should not have been made under 9C, but rather it has to be done under section 10. For that reason, as per Rule 34, mutatis application, we have applied this 49(2) and we have completed the assessment within 5 years. This is the department's case here. So now let's.
Why you were sitting more than 3 years? Why you were sitting? Let us see 49 applicability. Whether you can borrow that and for the purpose of limitation, because my brother, what it says is a substantive provision. It is.
34 is procedural, sir. 34, Rule 34 is procedural.
Limitation is.
Sir, for procedural aspect, can you adhere to, can you apply that to a substantive provision?
If the provision is not there,
That is what I'm saying. Now there are two ways that's the canon of interpretation as we understood. There are two or three ways of bringing the provision of another act into a
No.
is by way of an incorporation of the another act into the act, by way of a reference of the another act to an
Your Lordship.
and by way of any kind of interjections between these two. One can definitely borrow that particular notion of a third. There are no other ways that you can bring on the ground of perimetria is only for the purpose of interpreting the words of a particular statute, taking an external aid on the ground of perimetria. In another provision, which is also under the fiscal statute, which is also a fiscal statute where interpretation has been made. So why don't you take the interpretation here? This is what an interpretative tool. But you cannot borrow stock and barrel that this provision is infused into it, or except on three grounds. Then you'll have to say, I do not know what are the judgments which has been given, but I think from the Privy Council era, the things are more. Under the Government of India Act also, how it is to be borrowed and how the provisions is a standalone statute. Value-added tax is a standalone statute. It's an independent statute. And OET is also in a statute. Though both comes under the fiscal, those are fiscal statutes. Both are fiscal statutes. So you can, for the purpose of interpretation of any word in the one or other act, you can definitely take a aid of that. But when you want to borrow and apply the provision of another act into this act, then you'll have to say that this act, either by way of incorporation or by way of reference, you have to show that.
Your Lordship, for a moment, 34.
The senior counsel is very calm and quiet.
Your Lordship, my running senior is always, Your Lordship, we respect for these. We are giving so much of respect.
That inculcate a sense that even if the court is misdirected, let us calm.
Your Lordship, may kindly for a moment rule 34. Rule 34, Your Lordship, for a moment.
Please tell me that whether this can you show us.
Your Lordship, for any other matters, rule 34 of Odisha anti-tax rate.
Yes.
For any other matter not specified under these rules, but required for carrying out the purposes of the act and these rules, the provisions under VAT Act and the rules made thereunder.
Which one?
Sir, Rule 34. Rule.
Yes, I am looking at the rules of
anti-tax.
Anti-tax.
Entry tax.
Yeah,
Sorry.
because we are on anti-tax. No, Your Lordship.
Yes.
Yes. Yes.
34. For any other matters not specified under this rule, but required for the carrying out of the purposes of the act and these rules, the provisions under VAT Act and the rules made thereunder, shall mutatis apply.
The rules
Your
that is confined to these rules, that is procedural, not substantive. Very cautiously and consciously they have drafted this.
Lordship. Your Lordship, may I admit this matter? Let me take instruction and try counter because department's view is also because it is a.
What my brother says, it really reminds me of at least two judgments. In some of the act, the word is used as mutatis mutandis. In some of the act, it is used as far as practicable. That provisions can be applicable as far as practicable.
Such is the provisions of VAT Act.
Yes. So it says that not all the provisions of the act which is mentioned would apply. It is the principles which would be the guiding factor of that act that would apply. And right of limitation or the period of limitation is a substantive one. Can you borrow it? You can borrow the principle.
I have to file a detailed counter. My lord also knows that our department so long has adopted this.
I have
provision.
forgotten.
Adopted this.
I have
provision.
dissociated.
So I
No,
have
sir.
to. I have to
No,
go
sir.
extensive.
No, sir.
And I,
There are difficult situations.
I have to.
I tell you very frankly, I am not thinking about in the perspective of the fiscal statute. I was thinking about in the perspective of a civil.
Your Lordship.
Under the Hindu Marriage Act, you will find that the provisions of the Code of Procedure shall not be applicable in the matrimonial proceedings under the Hindu Marriage Act. It simply says that as far as practicable, the Code of Procedure will apply. And that was interpreted by the Calcutta High Court and the Supreme Court to be that it is the principles of the Code of Procedure which will apply. It's not all the substantive provisions, because it has an exhaustive remedy of appeal as well. It has the substantive, the provisions related to limitation as well. So the question arose that if the appeal is provided in the court, then in that event, this provision of an appeal in the act is misnomer, because we will follow that. It was held no. Can't.
Your Lordship, may I admit I have to
Can't.
find a detailed counter.
So that was really playing in my mind.
Your
Those
Lordship, I will also, I will examine Your Lordship.
in Section 41 of the Hindu Marriage Act.
Sections and provisions. So, just the code of criminal procedure. So, or not.
That means that.
In such a seizure procedure, which is laid down in the VAT, so far as it practicable, applicable, that is to be adhered from Code of Criminal Procedure. So that doesn't mean that entire Code of Criminal Procedure will apply. To the extent of such a seizure procedure which is not reflected in this. So when specific statute has provided you a limitation, can you bypass that by inhering into or adhering to the other statute? Read into this.
Because it is interest of the revenue at large, Your Lordship. Because many cases department has done this.
No, that's true. But very interesting question. This is a pure question of law.
Your Lordship.
Whether you can borrow 49 for the purpose of limitation, extending the period of limitation, which is a substantive right and is a substantive law.
I think to some extent, I have to accept that. I'll try to convince you. I'll try to convince you.
When you say, when we can fix, you have to admit.
For which chapter you? So I have to find out to be.
No.
For the tax periods 1/4/2005 to 28/2/2006 was framed by the order dated 2/8/2006 under section 9C of the Odisha Income Tax Act 1999 against the said order of assessment. An appeal was preferred by the assessee, which setting aside said assessment by the order dated 16/7/2019 with an observation that
Page 48.
if adverse materials supplied by the intelligence range could be utilized as escape turnover to make assessment under section 10 of the Odisha Income Tax Act instead of resorting to assessment under section 9C of the 9 capital C of the Odisha Income Tax Act. And accordingly, it is directed to initiate strictly in accordance with law. The person is strictly in accordance with strictly in accordance with the provisions of OET Act and rules made therein. Quotation please. It is suggested by Vivekanand Mahanti, senior advocate, that after passage of period of limitation contained in section 12, the department has scrutinized the return and accepted returns for the aforesaid period under assessment, and thereafter issued notice for assessment under section 10 of the
He initiated a notice first.
No, that
Then
is not notice. With great respect, that is not notice because the statutory notice E32, as per the rule 15D, has been issued after acceptance of the return. Your Lordship, I kindly turn to 2 copies. Your Lordship, the first is the page 57. Page 57, dated 31st 3/2023. This is the acceptance of the return. Your Lordship, page 60. E32. So that is fairly, that is a letter. That cannot be said that that is a notice. Because notice is to be issued as in a statutory form.
That case, it must have been.
In what he says, so
Your Lordship.
what you are jumping, we will record that you have refuted both on fact and law. No difficulty.
issued notice under section 10 of the OET Act. Section 10 assessment is over
Yes.
and framed the assessment under section 10. Mr. Sunil Misra, standing counsel for the CPGSP organization, submitted that as per section 49(2) of the Odisha Value Added Tax Act, the period, the appellate authority can be construed at court so as to so as to have the authority to proceed with section 10 in terms of the periods period of limitation specified under said provision. Instead of section 10 bracket 3 of the rules. This board.
And the only one point. The notice has been issued after acceptance of the return. That was their allegation.
It is submitted that
The notice in E32.
section 10 of the OET Act in form E32 has been served on the assessee after scrutiny of returns for the period 2005, I say period 1 for 2005.
Intimation.
And gets accepted.
necessary intimation. The acceptance has been intimated through necessary intimation.
Which was duly intimated to the assessed
Prior to notice.
prior to initiation of the reassessment proceeding pursuant to direction of appellate authority. This court is now called up to decide whether section 49 bracket 2 the limitation specified in section 49 bracket 2 of the Orissa Valuable Tax Act shall apply and save the limitation overriding the limitation specified under section 10 bracket 3 of the Orissa Tax Act. Issue notice counter affidavit required 4 weeks. So copy of
S. Ali. S. Ali.
Salil.
Yes, Ali.
S. Ali.
Syed Shahzad Ali. Justice matter.
Reopen
Hmm?
after vacation. After vacation.
After this,
19th June month.
Lots of 4 weeks.
4 weeks. 4 weeks.
Intervening in the vacation is after vacation.
This month. 19th June month.
Since this court comes, then it is case matter as an interim measure. As an interim measure, the authorities are restrained not to take any coercive measure pursuant
Or proceed on the basis of the demands.
pursuant to order dated 12/7/2022 passed by
Annexure 9.
9. Annexure 9.
Get
Please assist us on the next page, on the ground of the following of the provisions, how far it is permissible and in what manner it is permissible. Rule 34, which he has interpreted, which is notatis mutatis, how it is to be. You also.
Item number 4.
If I may, Your Worship.
What is that order you are complaining of?
Worship, in Annexure 1, order dated 7/11/2023. Lordship.
What was directed?
Lordship, in page number 31.
No, what was the ultimate decision which was taken? At what page?
Lordship, in page
31.
31, my Lordship. In para 34.
Yes,
I agree.
In para 30, in view of the above, the order dated 4/5/2012 passed by the Odisha Administrative
There is
Tribunal.
no time limit given. There is no time limit.
Sustainable is not liable to be coerced. It has no benefits as due and admissible to her, including the grant of revised skill of this.
Lordship.
In
Lordship.
accordance with law.
They have not yet extended.
No, Your Lordship, and this is the second.
Since
round of
2023.
litigation. Lordship, this is the second round of litigation regarding contempt petition. Annexure
In
3,
round of litigation regarding contempt.
contempt petition, Lordship, Annexure 3 is the first contempt. This court has
What is the date of the order?
29/1/2024.
Huh?
29/1/2024. Annexure 3, Your Lordship.
So in the
Now the time limit was fixed there.
Lordship, for 3 months.
three months from January 2024.
Lordship.
So almost more than a year now.
Sir, your lordship will call it 10 days after. In the meantime, I'll try to see that so high this order has not been.
Yes, already have you
Be a contemptuous act.
I having gone through these documents, I understand.
have you verified whether they have approached the Honorable Supreme Court?
No, Your Lordship, they have not approached.
Sure.
I have the instruction, they have not approached.
So it's-
Was just inquiring about it because of the first day when the contempt is known, that is under the contempt of court, that is the first motion. When it is more, then at least you are entitled to a notice
Yes.
and a notice to respond. Since you have already appeared, you have an authority to appear for the LS contender. So we record the waiver of the notice by you. By Navaгаlatnama within a time frame.
Yes.
And then give you a response.
Yes.
And if you find that the explanation is unsatisfactory,
Certainly, my lord.
then
Certainly.
rule
Certainly,
is the
certainly.
only rule.
There cannot be a second opinion.
How
over
can there be a two contempt?
Earlier it was not there.
Sir, you have instructions to appear on behalf of the contender.
No, as a matter of fact,
Why?
contemner by name, he has been made a contemner.
Has to be.
Yes. I have I have not been
Why you are
instructed by
very-
the officer.
Then why you are appearing?
Normal practice prevailing in this court, my lord. Since that officer, in his official capacity, is to come implement the order, that is how. But I was proposing, my lord, subject to your lordship's acceptance,
Yes.
10 days time is for me, and if I will be successful in getting the order implemented within these 10 days time, my learned friends, client, possibly will not have any.
Possibly. Why already you have overstepped.
No, that I concede. That I concede.
You have already committed contempt.
Yes, that I concede. But I possibly, rightly, I place. I will try make an endeavor to see that the order is complied with.
No, you have committed contempt of contempt.
I concede that extent,
There is
man.
one judgment of the Supreme Court, three judges bench. headed by Chief Justice of India, Justice Kapadia. Similarly, when the court has directed something is to be done within a time frame, it is not done. Such government and lethargy, these are the two special words used by the Supreme Court, and amounts to a contemptuous act, and he should be punished. 2000, find out, 2012 or 2013. Supreme Court, either in SCC, I do not know, page 600 or something is there. Key judge bench headed by Justice Kapadia is with their laws. Very strong word. Find out 2012 or 13. You'll find that judgment. You will not read that judgment. But it's after 10 days or sorry.
Sixth or seventh, as you not yes. Sixth or seventh.
By next week, you get the instruction.
The
What
instruction.
is the stage? What is the stage?
Yes.
So that it is complied or not, you come back with compliance only.
Yes, that's what I'm saying.
Yes.
Yes.
Pick out that judgment and come. So you also go through that judgment.
Yes. There cannot be a second opinion, even in absence of that judgment also. My lord, I cannot defend.
Submitted that the authorities had been allowed 3 months from the date of communication of order district 29 and 24 passed in contempt COMPC number 201 of 2024, which has already been lapsed, but no benefit as contained in the guarantee given at printed so at this stage, Sri Bindusandhar's additional government advocate appeared and seeks a 10 days accommodation to record the compliance of the procedural. List this matter on
6th May.
6th May.
Item number 5.
Here, my lords, due to technical glitches of the server of the department, my uploading of the audit report was delayed by 8 days. That is why the CIT exemption rejected my application, although the CBDT circular has extended the period of limitation. That
Why the CIT exemption was so rigid?
I don't know, my lords. They are the
Because you are habitual.
habitual man
That is
without
the-
any instance.
That is the wording here.
They have,
You are
yes,
in a habit of
yes, that's what is rejected. And my lord is already well aware of the fundamental principle that each assessment here under the income tax or this revenue law is a separate here. You cannot just only the difference is the Supreme Court judgment in that Swami Satsang by Justice Ramnath Mishra and Kuldeep Singh. They have said that the judicata will not appear in some cases. That is 193 idea.
if I remember. But your lordship will be pleased to see, I got the registration certificate.
So we will remember, Senior Counsel, that each assessment here is a separate one.
Separate.
Having no
Because-
nexus with the other assessment.
Yes. There is no res judicata cannot be
If
applied.
you come and argue in one matter and say that this exemption was already granted in respect of a
Yes.
earlier year.
Yeah.
So you are
Yes.
entitled
Well,
to exemption in
that
this
is-
year as
That
well.
is absolutely so
We will
far.
not accept it.
My lord, that is subject to now here, my lord, so far as this case is concerned.
We understand. What is this? There was
now-
technical
well,
glitch.
No, my lord, there is
The
no.
CBDT has extended the period.
Yes,
Why is it
CBDT
not?
has extended that. I will
My
bring
lord,
to your lordship's
February, there was a delay of
Sir, Honorable Supreme Court in January 2022, 10th January 2022
Well,
has extended the limitation for all
yes,
till May. From February, the lordships have said within 90 days, whosoever have not filed. So May 22 was the last date
Well.
for appeals and all. So what is the dissimilarity in it?
in line with what my lord has said. Just a minute.
So much agreement was
Probably,
taken
yes, so much
by the
extent that
Honorable
period of
Supreme Court.
limitation, taking the pandemic, they have
Then
issued.
this period he has filed on 23/2/2022. It
Yes.
seems.
And where is the CBDT circular?
Annexer 7, page 31, my lord, please to get it.
So that is the department's.
CBDT is empowered.
No, I know.
Yes.
Sir.
Definitely. I bow down to what my
Yes,
lord.
what is,
Yes,
was,
yes, 31.
this was assessment year, which assessment year?
This
2021, 22.
21,
not 22.
22.
21, 22.
Yes.
So,
And I have given lordship, first I'll take your lordships to the circular issued by the board. That is Annexer 7 at page 31. My
I'm
lord,
looking at 11 January 2022, sir.
sir, the due date of furnishing of audit report. May I play the paragraph? My lord?
No, it's further extended up to 15 February 2022.
Yes, which was in the case of assessment referred to in clause A.
That was 2020, 2021.
Yes,
Previous year.
That's why I'm saying
Assessment year is 21/22.
22.
and hereby extended to 15 February 2022. And I have filed before that.
So,
And I have filed before that.
But there was a delay of 8 days, 23rd February 2022.
23rd February.
Yes.
23rd.
So,
Or beyond consent period.
No, no, no. No,
that's if you are within that 15th, no problem. Yes. Sure that you are within that 15th.
yes, yes. I'll just now. Lordship may kindly see. Annexer 3. Annexer 3, my lord.
So you must have seen the extended period for returns.
No, no, no. For
You
the
misconstrued that to be filing of
Appeal.
the report, audit report.
yes.
For audit report, it is
Yes.
15th February,
My lord.
right?
Right.
For furnishing return, it is 15th March.
15th March.
So perhaps you are under that conception.
No, my lord.
That-
No. Lordship may be pleased to see Annexer 3 at page 16. Date is there, date of audit report, 28th of January 2022. Lordship may be pleased to see.
Yes. But whether it is uploaded.
Uploaded, that was due to the page 19 matters may be pleased to see.
This was that because of the technical glitch, it could not be uploaded along with that.
Technical glitch. Can I bring to your Lordship's kind notice? And page 19. Page 19, Lordship will see. Date of
What?
28th of January.
It's true, no doubt about it. Sir.
Yes.
Question is that is what the report
Yes.
is from the auditor.
I have to upload it by 15th of March. Yes.
So show us that you have uploaded within 15th of March.
Manners, that is, there was some delay. There was some delay due to what? Due to the server technical glitches of the server of the department for which I cannot upload it. And
Where is that evidence that
yes,
screenshot you must have screenshot?
Screenshot, sorry, my lord. I have, may I bring to your lordship's kind attention to page 27. When I was issued a so cause, for condonation of delay.
They must have screenshots. When it failed,
Yes.
so for failure also, server down and it could not be done. There is a message and that screenshot you must have.
And may I bring to your lordship's kind attention to note. Your lordship may see page 27. Page 27, ma'am. Well, let's
There is a provision of law that he has the power to extend the time of condone.
Commissioner.
Yes, you have approached the Commissioner of Income Tax.
119
92B.
Yes.
That is the power.
Yes. 119(2)(b balance that empowers the I'm just reading up. Without prejudice to the generality of the foregoing power, the board, if it considers it necessary to expedite
The board
Yes.
is the Central Board of Direct Taxes.
Yes.
Constituted under the Central Board of Revenues Act.
Yes.
Now, whether the Commissioner of Income Tax exemption.
Yes.
Satisfies the definition of a board.
Yes. that satisfies my lords. The board may, if it considers it necessary or expedient so to do, for the purpose of proper and efficient management of the work of the assessment and collection of revenue, is time to time, whether by of relaxation of any provisions of sections, and the sections are mentioned, subsection of 201, all the sections are there, my lords. Now, all special order in respect of any class or income or class of cases setting forth direction.
That comes under 2E. It
Yes.
says that it is considers desirable or expedient
Yes,
to do so for avoiding a genuine hardship.
yes,
In any case or a class of cases by a general or special order authorizes any income tax authority, not being a joint commissioner appeals to admit an application or claim for exemption.
yes.
Deduction
Yes,
for the
claim for
that
exemption.
is after the expiry of period provided.
Yes.
So that can be done. So now I'm talking about a board.
Yes.
Because I find that the income tax authorities section 116,
Man.
it talks about the classes of the income tax authorities for the purpose of the act. Then this board is to be constituted.
Relaxation.
And I do not find, I find that he comes under C, is a separate class. That is what
Yes.
I'm saying. If he is kept in a separate class, then he does not satisfy the definition of a board.
And the board has issued the circular under Annex 7, man.
That is the deadline.
Yes, deadline.
You have crossed the deadline, sir.
No, sir, I have.
You crossed the great deadline. It was the 15th of February. You admittedly acknowledgement which you have
28th
shown is 23rd. So it was beyond 8 days.
8 days.
Correct? Now the power to condone or relax this 8 day must emanate from the statute.
Yes,
You have approached the Commissioner of Income Tax Exemption.
yes.
You sought for condonation. Please
Correct,
permit me to do it.
Man,
Now,
correct.
now
Now,
who
my
can
lord,
do it? You
may I-
say 119 2B.
Yes,
Because I find from page 24, your application,
yes,
which you have made, you have referred the provision of section 119 2B.
yes.
Section 119 2B talks about the power of the board to condone it or
Yes.
extend it.
Man,
Then I
Now-
refer to section 160,
yes,
where it says that who can be a classes of the income tax authorities.
man.
It talks about that these are the following classes of income tax authorities.
That
A talks about board. What is that? The Central Board of Direct Taxes.
yes,
Then
power is
B,
given.
correct. The C talks about clause C,
Yes,
Commissioner of Income Tax.
yes,
So if both the authorities are kept in a separate provision, then they constitute a separate class. So this Commissioner of Income Tax cannot be a board or a board.
he is working under the board, my lords. He is
Now,
working.
if the power is can a person working under the board exercise such power? I don't know. That's all.
My lords, he is bound by the instructions.
No. Commissioner has included into C.
May be pleased to see page 27. When I was issued a so cause as to why my application shall not be rejected for delay, whereas I replied to that effect. Lordship will be pleased to see the society was registered column number 4. Then, my lords,
So the question is only one thing, sir, that troubles me. I'm just asking you a very simple question.
man,
The board has extended the time
yes,
for filing an audited
report,
reports.
yes, And that has been
The
extended.
deadline is 15th of
February.
Extended.
And before that, I have uploaded.
No, that it appears because your audit report is dated 22nd of February. After 15th, uploading acknowledgement which you are claiming is of 23rd that you tried to upload. So it was all admittedly beyond 15th of February.
Percy may kindly, I will answer
Please,
your
please
question.
come to, I'm
Yes.
just giving you, they please come to pay, please show us.
Yes. Matters may be pleased to see
Please,
page 49.
audit report is at play at page.
These ballots,
Audit report is at page.
annex to 3, page 16 ballots. Form number 10B, that itself is the audit report ballots. Form number 10B is itself the audit report.
What is the dates? Just taking.
Yes.
I was taking that.
Yes.
The audit report is 28th of January.
Yes.
Correct?
Yes.
Now,
madam.
Now, please.
Yes.
Then come to the next.
Form number 10B is itself is an audit report balance. In order to get exemption.
Sir, you come up to this page. This, come to page 23, election form.
23.
What is the date on the right hand side top? It's an acknowledgement receipt of an income tax form.
Yes. Date
So
of
in the form
e-filing.
you have to, what is the date, right hand side set top?
23rd February 2020.
Beyond 15.
I don't disagree with that manners. I have
And what is the form description?
manners.
Form description is the audit report.
Audit report. That is manners.
So it was definitely beyond 15.
Manners, that was on 28th of January.
So that when you say audit report talks about when the receipt is generated, it is 23rd.
Manners, this.
Now the question is that whether they have a power to condone.
Yes, they have the power.
On a ground that I wanted to upload
Yes.
because of the technical glitch.
Yes.
I could not upload it.
Yes, yes.
I
Manners,
could not upload it.
Yes.
Now the question is who can condone the deed?
yes, that condonation can be done by the CIT exemption.
Show us any provision that he can.
Manners.
That is what I really wanted to
That-
harp upon.
Manners, I am going to answer and lots to see page 29 of my explanation.
Probably what I.
That is no.
Mr. Rai,
If I may share.
Mr. Rai, Mr. Rai, what, see,
I am asking something different. You are taking me to the explanation.
Right.
Let us take.
Yes.
Let us take.
Yes.
You have the best possible explanation available under the earth
Man.
or under the sky.
Man.
Let us proceed. And if it appears that you are beyond the time,
Yes.
then the question is who can condone or extend the time?
Man.
Who?
Ballots. Here ballots.
Who can extend?
Ballots so far as I have enclosed the judgments of the Honorable Supreme Court that a period of extension of period of limitation, and I am covered by that.
So who can extend?
Ballots, it can be extended by the Commissioner of Income Tax Exemption,
To what?
taking into cognizance of the Supreme Court orders.
Mr. Rai, your consideration is under section 1192B.
B.
1192B specifies it is board, not person concerned,
Because
person,
ballots,
authority concerned.
and for last 300, 400 years, I am here. So I have forgotten Bengali. Please. I speak, ballots, may I just to bring to your lordship's kind notice of the judgment this bench has rendered. And after taking the same consideration and your lordship have given it, remanded back.
That time perhaps we have not read this statute in this line.
Then
That 119 2B.
my lord can read it is already like Brahma, my lords, whatever your lordship say is law. We, after looking into the explanation to offer, and the fact that initially
That was the case that explanation which was offered was
Yeah.
not satisfactory, means that power to control is also there.
Same
Control that was, I do not know, but now when you invited my attention to the provisions, then a person should not remain ignorant throughout his life. If one day some enlightenment will come.
No, my lords, correct, my lord. Lordship will kindly see the rejection of my explanation. Just have a glance. It is, my lords, expert. No opportunity of hearing.
Question is that who can?
I have given
May I give a very bad example? May I give a very bad example? Suppose I have a broken chair. I approach the goldsmith to say that you repair it. Can he do it?
beg your pardon, my lords, I couldn't hear it.
Question is that who can repair it?
The carpenter?
But I have approached the goldsmith.
No, that is it's not synonymous with the smell.
But consider the same case, because if the board is the competent authority, whether the commissioner of appeal, exemption can exercise the power of the board. Can he do it? I'm just asking this very simple question.
So, my lords, so far as lordship kindly see the order which is under question, para 6 at page 13, my lords. Directed the department to file counter to have their say. Last order of this honorable court. No, not this one, matters. This honorable court directed the revenue to file, to take instructions. Last order may be pleased, may kindly. And there was no instruction to that effect as to why this was correct. I could have.
So according to you, silence tantamounts to acceptance.
Not that, my lords. What is that I don't say. My lords, what was the reason that this whether I have alleged that the departments
That judgment was not taken into account. So we want to hear, and we do not agree with this.
you are
I am a very bold person in this regard. Since you have cited, I will make the observations to that.
Lordship may pass the order or
The seminal point involved in the instant appeal. No, sorry. The repetition is taken out by the SSC, sending the order of the Commissioner of Income Tax within bracket exemption, refusing to extend / condone the delay which occasioned due to the technical glitch and cannot be attributable to the conduct of the SSC. The attention of the bench was drawn to section 119 2 within brackets 19 within bracket 2 within bracket small b of the Income Tax Act 1961, postulating the condonation or extension of time provided the circumstances appears to be beyond the control of the said provision. No, sir, sorry, the section 109 2 within bracket small b of the Act is reproduced as under 119 within bracket 2 within bracket b of the said Act is reproduced as under. On a bare reading of the provisions as quoted here in above, it says that the power to admit the application beyond the period can be condoned or extended by the board.
Section 120 may also be seen.
By the board.
Jurisdiction of the jurisdiction of the income tax authorities that confers jurisdiction. Section 120 is concerned about the conferment of jurisdiction on the officers working under the board. Lordship may kindly see.
This was the conferment. It has to be conferred. Unless there
Yes.
is a conferment delegation, you can't exercise.
Yes, that. Whereas the Chief Commissioner of the Commissioner of Income Tax exemption is conferred with the power to grant exemption or to refuse the exemption.
Can be controlled or extended by the board. Correct. Meaning thereby the Central Board of Direct Taxes constituted under the Central Boards of Revenues Act 1963.
61 madams. 1961.
The Central Boards of Revenue Act of 1963. It's a printing mistake, I do not know.
Act is 61 madams.
That is the Income Tax Act.
Yes.
I am talking about the
CBDT.
Board of Revenues Act, Central Board of Revenues Act, 1963. The question thus arose whether the Commissioner of Appeal within the function.
Not appeals, madam. Commissioner of exemption. CIT exemption.
CIT exemption. Can exercise the powers of the board. Full stop. The attention of this court is drawn to section 120 of the Income Tax Act 1961. That the power of the board can be exercised by any authorities, any income tax authorities, as is here. We find that the commissioners of income tax without any further qualification is included in clause C of section 116 of the Act, whereas the Central Board of Direct Taxes was shown in clause A thereof, and therefore it prima facie appears that both the authorities are distinct and different. So once those authorities are independent, the usurpation of the power without any further conferment or a delegation by the authority can be impinged on such ground. However, this is placed upon an unreported judgment of this court in case of Messrs. Joharimal High School, Cuttack versus the Principal Commissioner of Income Tax Exemption, Hyderabad, and others. Within bracket W3C number 3183 of 2025, where one of us with my condone the disposed of the petition, accepting the condonation of delay in filing the form 10B beyond the stipulated time. In the said report, neither the appearing counsels argued the point as noticed in the instant case, nor the court has an occasion to go into the nuances, the applicability of the aforesaid problem. To take a final view on upon harmonizing the same. We therefore invited the attention of the councils to address us on such a spot for which we permit them to file short notes of the submissions. Man. Right, on the next stage. Next.
Subject to correction, sir. It's not. But there is a power mill of 16 of 2024. There's a circular.
This is what my brother is.
I have seen that. That mill of. So that circular.
Yes.
He's not referring. I just said with conferment or delegation of power.
Your Lordship may allow my learned friend to produce the circular with your Lordship. There was a large number of pages. No, don't be obliged to me. Because that circular note.
Mr.
Asking whether there is a, because I have seen section 120, which says the delegation of power.
This 119.
Delegation of power.
This 114
Principal
be.
Commissioner as well as Principal Chief Commissioner.
Wanted that.
And period has been mentioned.
Now,
And all
this particular circular note will help my learned friend now. Because it calls out now.
Mr. Kaur, we have not disposed of.
Dear
He
Lordship.
wanted a short note.
Dear Lordship.
When they get the circular,
Dear Lordship.
when you are asking.
No, Mr. Kaur, since you have shown the anxiety,
Subject to loss
we
of
want,
continuity.
Whenever.
The order, the earlier order will continue.
we wanted whether after CBDT may be outline date, the PCT can condone the delay beyond that period.
It is with that is reasonable cost.
CBDT has given the last
Circular,
date
that's
for
all.
Form 10
Yes.
to be filed within 15 February 2022. So admittedly, there was 8 days delay beyond 15 February. So can the PCT extend that period?
Only I think it's your lordship's 22-26 jurisdiction will be invoked. If my learned friend shows sufficient cause for the
Yes,
delay.
reasonable
Dear
cost.
Lord,
Was prevented
in this circular, CBDT superseded all the earlier circular and given the power to the Commissioner and Chief Commissioner to, and also the period has been mentioned. That Commissioner will extend 365 days and
Our full bench decision may help. If there is no power to condone is given, then 5 of the Limitation Act will
apply.
So that full bench decision of our court.
But your
We
lordship,
just examine that.
but your lordship would permit my learned friend to produce that circular where the number of days.
Yeah, Steve, the short notes of submissions produce that circular.
This 2024 circular. And notification circular, you have stated it is notification. Notification of? Whose notification? CBDT.
Board has given
Under 119 2B.
So notifications are issued under the statute by many.
By only
It
CBD.
is the
Maybe
delegation.
from the Income Tax Department or CBDT.
This board has given the notification for the specific section, the 10B so far as form, to condone the delay in filing of those forms. I'm sorry. I'll just,
Mr. Mahanti, you should have.
So we have kept this matter, we have not decided it, and granting you a time to do it, because what is stuck in my mind, that has to be clear. It can't be.
It has a large impact.
All the members of the bar jumped. Can you imagine?
It has a large impact.
The way it has written.
Mr. Mahanti, you should have brought forward.
Yes.
This.
The term is the reasonable. If there is some reasonable hardship, so that is.
Sir, for 8 days, it is not inordinate.
Only your lordship can condone the delay and direct to consider. Because in board has directed, if the commissioner cannot do this. Well, I was appeared so many cases. Only your lordship direction that will reconsider, and if the regional cause is there, then commissioner pass out and condone the delay. That is what the
There is a circular notification that has come. And
Delegation.
The question is the conferment of the power, unless the power exists.
Yes.
Then access can be made. If there is no power, then it cannot be exercised. The question is whether this power can be exercised.
Only in sufficient cause.
Now question is again, and there is no period which is given. And it talks about the board's power to condone. And he says that the power of the board is really delegated to those authorities.
Yes.
By virtue of a notification, 16 of 2024.
That is what Mr. Misra has given us.
It has been conferred. So if that is conferred, then
You can direct to reconsider if regional cause is there.
Sir, we cannot confer any jurisdiction. We cannot confer any jurisdiction on an authority if statute prohibits or doesn't specify so.
Only based on section 5 law.
only limitation act. Your Lordship can.
You are talking about the authority. I can give you two judgments of the Supreme Court which says that by virtue of an order passed by the Supreme Court, it cannot confer a jurisdiction on the court which inherently lack jurisdiction to decide. Even a Supreme Court by its order cannot confer a jurisdiction on the court. If the power or the jurisdiction is not there, if in exercise of 226, say you do it.
And so far as jurisdiction is concerned,
Oh,
on that day,
That is why I
concentrate on that.
that's why I referred to that Akshay Kumar Corridor, 2015 ILR of full bench judgment. Mr. CORAM also.
Yes.
I have.
Yes.
Item number 6.
Thank you.
My lord, this is an inditex matter. I have challenged the order of the commissioner dated 17/1/25, rejecting my revision petition for restoration of appeal for the period 1/10/2005 to 30th June 2017 due to non-deposit of 20% balance tax of 4,99,999. My lord, my due to the financial constraint and closure of the business, unfortunately, I could not deposit 20% of deposit.
See,
Yes, yes, just. Your Lordship, I am under similar circumstances, under the OPAC Act, the legislature has reduced the percentage of 20% to 10% in the year 2017. I have the capability.
Mr. Rai,
Yes,
there are orders innocuously passed.
yes.
That I am aware of. I think that is in 2014 or 15.
Yes. Yes. In other cases also, this court has also directed to deposit 10% also.
Those orders will not to your benefit.
Your Lordship can.
I was there. I was.
Your Lordship is understanding.
Yes, I was objecting. But now I am to decide whether statutory prescription we can reduce.
You can. Your Lordship.
There was no law laid down there.
No law. Your Lordship has discretion to reduce.
No discretion is given.
Your Lordship has the power to reduce from 20 to 10. I can deposit 10%.
Can a court rewrite a statute?
Now,
Can a court do it?
I'm not talking about rewrite.
This is what if the statute is the method, can a court say 10% down?
Earlier occasions, similar.
I don't know why it has been done.
Yeah.
But I have some
I obliged,
My lord,
so because I have to go by a statute. I have to go by a statute and to interpret that statute. Even permits only 20% statute, then how can we relax?
In the earlier occasion, it has relaxed.
How can we? Under what authority?
This court is relaxed.
226 should not be exercised in that. In para not uncontrollable. Or
in para. This court
You are
has
giving
similar.
My lord is the author of that judgment.
And deposit 10% of the para 5.
Negative, Your Lordship.
Para 5.
Your Lordship rejected the application.
Para 5.
Just
10% of the disputed tax amount.
Paragraph 11.
absolutely has to be.
My humble submission, I've already deposited for 44,000 some odd.
Yes, sir.
Para 5.
That is statutory.
Even then rejected. I can read your lordship mind. Mananjan Chakravarti case has been discussed,
My lordship,
but rejected not to interfere because these are statutory.
just to reduce from 20 to 10% so that I can deposit and restore that.
Statutory.
It is not applicable here.
No, no.
Here even that 34
Sir, there are two things. One is statutory deposit. Second aspect is stay
Money.
of the stay of recovery of balance of 50%. So 20% is mandate.
Money.
There is no doubt about it. But under that, as amendment was brought up, saying that once a pre-deposit is made, no further appeal is dismissed. Similar amendment could not be brought out under entry tax for obvious reasons. So Commissioner has issued a circular saying that under entry tax, if you pay the deposit, don't insist for rest till appeal. That is
your lordship has taken.
No, I have not taken.
No.
I have just referred to Commissioner's
Your lordship.
circular.
Your lordship.
So in view of that, you cannot argue beyond that.
Your lordship. No, what I pay, let him deposit.
He has not discharged. Even 20% also he has not discharged.
Have to deposit 20%.
So after deposit, let him file the state return as well. So it will.
10% is there.
No.
Because VAT Act, it has been reduced from 20 to 10.
No, sir. There is a law. There is no decision. A ratio is binding on about it. Provided the law is discussed. I do not find from those orders there is any derogation of a law. It is purely on surreptitiously, may I use the word more bluntly, jump to a conclusion that yes, you deposit 10%, that's enough. That is not the law. It is no ratio which binds us. And there are judgments which has come up. The division bench judgment of 4/4/2022, which talks about that no, there cannot be any tinkering with the statutory. It has to be done. That would deposit.
Orissa entity tax is not amended, reducing the 20 to 10.
It's confusing. You have to. This statute cannot be rewritten by us.
Now, we are not, I'm not guessing that.
No, sir.
Because
The issue was that which provision?
16.
In terms of section 774 of the law and section 64 of the correct. For rest of the he will file
Section.
That's good.
Section 16 subsection 4.
Section
16 subsection 4.
That I'm not discussing. That was not amended.
20% of the tax and
Yes, yes, ma'am.
So 20% you have to.
My lord, it comes to rupees 5,44,880.
Nothing. It's a very negligible amount.
Now, out of, because my farm was closed and what the total business was closed. That's why I pray.
Oh.
In other cases, we are immediately depositing.
And only balance is 4,99,990.
So we have to, that's a statutory mandate.
Yes, Lordship direct.
What to do? We have to simply say we are not interfering with the order and then simply say that if you deposit, then
On deposit, my.
because the word is entertained.
Your Lordship, on deposit, it will entertain.
It does not talk about maintain.
No. Annexure 3, Your Lordship, the order may be,
Your Lordship may direct.
the informed order.
Annexure. Annexure may be restored. On deposit.
Annexure 3.
The order of 17th January you are received.
Asset.
The order dated 17th January 2025 passed by the
Commissioner of Sales.
Commissioner of
Sales.
Commissioner of Sales Tax.
Yes.
17th January is in continuation to February.
Sales tax. In disposing of the petition as the condition for pre-deposit of 20% of the disputed tax / demand has not been complied with. The attention of this board is drawn to section 16 bracket 4 of the OET Act 1999, which provides that appeal against an order of assessment shall not be interfered with appellate authorities unless accompanied by a satisfactory proof of payment of admitted tax in full and 20% of the tax of the interest of both in dispute. The moment we start once the statute has put a condition for entertainability of an appeal as condition precedent, such appeal in the absence of the compliance thereof is not liable to be entertained by the appellate authority. The entertained has to be construed in a more pragmatic manner. And should not be used jealously to secure the dismissal. Stop. Unless that deposit mandated under the same provision is made, the appeal would remain a dead letter and shall not be entertained by the authority. The contention of the appellant that they may be permitted to deposit 10% of the disputed tax / the disputed tax, we do not find any reference of this in numerical verb. But what is sine qua non to make the appeal entertainable is to deposit 20% of the disputed tax or interest or both. Full stop. The court cannot pass an order which per se is contrary to these statutory provisions. The court can neither rewrite the statute nor to incorporate any words into the provisions, statutory provisions. When the language used therein is unambiguous and conveys a laudable message without any further interpretation to be made in this regard. Next one. It is manifest from section 16 with the bracket 4 that 20% of the tax or interest or both in dispute should accompany with the appeal so that it can be entertained by the authority. And therefore, the contention that the writ petitioner should be permitted to deposit 10% thereof is unsustainable. Considering the spirit of the statutory provision, we permit the petitioner to deposit the 20% of the disputed tax.
It's an interest.
Tax, tax or interest or both. Before deposit should be the deposit, and in the event of deposit of the same, the appellate authority shall entertain the said appeal and may pass an appropriate orders as permissible in law.
Because if your lordship will not direct already appeal has been disposed of. It will be
2 weeks. No, 4 weeks. 2 weeks. Don't bother. 2 weeks.
They're passing very hard. 4 weeks. I undertake 4. Within 4 weeks.
3 weeks.
My lord, one word. 44,000 some odds I have already deposited.
I think it's the appeal order itself. On deposit, your lordship, annexure 3 will be restored. Annexure will be restored and appeal.
The reservoir, the maintaining water, the permissible limit during rainy season. During rainy.
Whether have this structural stability certificate.
Yes, madam.
It can bear the extra load as
yes,
well.
that instruction I have received, madam.
Yeah. If that is there, then you can't say that it should be there. Because in rainy season, there is no,
Your Lordship,
increase
I have-
in the amount. Yes, life and the protection of the property is to be ensured. But if it breaks, then it will create a havoc. Disaster.
Lordship, my submission kindly asked to the
My lord,
Mr. 10, Your Lordship, catching
catchment
information.
catchment area
During the December,
of that upper junk
December
irrigation
is not the
project
rainy
file.
season.
No,
Your Lordship, kindly glance to page 38, Your Lordship.
no, they are saying that it is during the rainy season.
No,
And
this is
you
wrong,
are-
Your Lordship.
you
Complete-
sure.
Completely
And
wrong.
the periodical release of the water is also very important.
Yes,
Because that catchment area of the upper junk reservation project, upper junk irrigation project, that is covered by hills. So during rainy season, the inflow of water is much more.
No, I understand.
So in 1989, a decision was taken to increase the height of the dam, and the assessment was, and the height was increased up to 157 meters. The Lordship may kindly have a glance to this instruction. The earlier instruction is also there on record. Top level of the tank, Your Lordship may kindly see, that is 357.60 meters. Now, the permissible limit is
Top level.
top level of the tank, top bank level. Your Lordship, the instruction I handed over. But
You are referring this?
no, my lord. I'm referring to
Yes, top level, bank level.
top level, that is 357.60. And the full reservoir level is 354.10 meters. And the permissible limit is 350. So during rainy season, we don't go beyond this 354.10. And it is only to, because if the water is allowed to flow downstream, then in downstream area, my lord, the habitats that will be affected, markets and buildings, and even a bridge connecting Odisha and Chhattisgarh, that will also be affected. So that is why during rainy season from June, this level is maintained.
And thereafter it is reduced.
Thereafter it is reduced.
Well, then you are periodically releasing the water. It's not that it's a stagnant water.
Yes, my lord.
Because this dam is used for the purpose of, the diverting the water to a different parts.
Yes. For irrigation and other things, it is also done. So it is
lawsuits. Before rainy season, they should maintain a minimum level of water. There is a management system like a Hirakud dam. They should maintain a minimum level of water before the rainy season.
Where is the Hirakund dam? What is the scheme and what are the regulations is there for?
They have in the upper zone, they have a management system, water management system.
That is what they have said. And this is what I am doing here. And we are following all the norms which are required. Even there was a structural audit that whether how it can be done, and that suggests the increase of the height, and this height was also increased. And they say the minimum water should be ordinarily is preferable to this 350. In a rainy season, it crosses 354, but we maintain, we do not permit to go beyond it. We always keep a buffer or a space because it is 357. So it is nearly buffer space is maintained 3, say, meter space. What more, sir? Who are you?
So we are the villagers.
Villagers. So what right?
Actually,
the dam is created for protection of many things.
Yes.
And you are also beneficiary.
Your Lordship, actually happens.
Cannot. Everything you cannot come up.
I applied it.
Come up. Do you have the SOP?
SOP, I'll produce.
Maintaining.
I'll produce that.
You please produce that what are the standard of operating procedure or what the standard procedure you follow. And what are the mandates which has come?
Yes.
We'll pass the the order and dispose of this kind of a PIL, not right?
And the
It will
previous
indicate that this is what is.
which is affecting the tiger reserve forest and the tiger are forming outside. I am Alex
What
12.
the tiger is?
This is a tiger reserve forest. The dam situation is tiger reserve forest.
Right.
And anything you require any efforts
So you
to have.
want a removal of the dam?
No, your lordship.
We will remove the dam.
No, your lordship.
We will remove it. Remove the dam. So that will affect all
the excess
development
water
of the.
Lordship, the excess water affect the reserve forest and submerge the deep wildlife forest. That's why
Have
the
you,
tiger are
have you
forming.
visited this irrigation area?
No, I don't.
So,
That's why. It is an irrigation project.
Lordship, I am planning to glance to the Supreme Court's order, your lordship.
true, no doubt about it, but
Yeah, I was illegally increased by the irrigation department.
that is what the structural audit was given. Can they not? That is they have to follow the norms. If they have followed the norms, then how can you say?
Your lordship, may I pray to take instruction from the
Nothing instruction is required. They are required to produce the documents.
Your lordship, the involvement of forest department highly is it?
I have not come across this. Giving a comprehensive that there must be a SOP this which you maintain. Yes, there must be a guidelines that this is what is to be followed and please produce that guidelines. Yes. And on the basis thereof that you have to strictly follow those laws.
Lordship, my prayer is the views of forest department also required as well this matter. Kindly.
Forest is.
Well, the allegation by the state is to act. The Minister of Environment and Forest has no role to play in this case.
And the allegation by learned friend is
They have watched
no, your lordship. The Supreme Court had directed the duty of the Minister of Forest, your lordship.
My lord, towards afforestation and compensatory forestry, 548 acres has already given to the forest department for this purpose.
Already admitted by the Honorable Supreme Court.
That I have given in my previous instruction.
First, you pick up your mind. You wanted the closure of the dam, no restoration of the forest. Make out a case like this. Your remarks is that they should maintain a level of water only.
Only permission limit.
That's all.
Yes.
Then for SOP, then the forest department has nothing to say about what they will do. So, pursuant to the earlier order, the letter issued by the Superintendent Engineer, Noapa Irrigation Division, is why today is indicated in the said report that initially the total door capacity of the reservoir of the dam was 350.60 meters. But Office decision was taken subsequently to increase the height of the reservoir to 357.60 meters. As the authorities found that during the rainy season, the level of the water rapidly increased. Obviously, such obviously the height of the reservoir was raised upon undertaking the structural audit, structural stability audit, so that the excess amount of water during the rainy season. Can be safely stored. It is submitted by the council for the states that the maximum water level after the increase is maintained at 354.10 meter during the rainy season. Otherwise, the storage is up to 343.50 meter, much below the height of the said reservoir of the dam. The petitioner is still unsatisfied with the aforesaid disclosure. According to him, the forest has suffered for the release of the excess water. First of all, the forest department does not concur with the views of the petitioner and submits that it is the responsibility of the state to take care of the same, meaning thereby they do not have any other grievances in this regard. In order to streamline the functioning of the dam, the storage of the water, both in rainy and other seasons, and the standard maintained for operating the dam, we direct the state to submit the relevant documents in this regard. This is the matter that we are listing with after 19th June. Yes. For the list.
Item number 8.
What? Why?
Further instruction from my client.
After?
Yes.
Yes. After.
1960. 19 Item 9.
This is a matter under the GST Act. There was an assessment made against me. I filed an appeal. There were manual orders, I filed an annual appeal. And the appellate authority fixed the appeal for final hearing. At the time of final hearing, I submitted on merits, and the matter was closed. I submitted a written note of submission. The matter was closed order. While going through the papers, he found out that the pre-deposit was not made. Instead of giving me a notice as to why pre-deposit has not been made, he disposed of the appeal straight off. And the ordering portion is at page 37, my lords.
What is the language
My lords,
of section?
107. My lords, 107 talks about pre-deposit.
For the purpose of filing, or entertaining?
What's 107 subsection 6? Yes, my submission is that you have given me a notice as to why you have not filed deposits. The main issue here is when this transition awareness.
Sir, the difficulty when you file an appeal, you know the provisions because the language is that it cannot be filed. It cannot be filed.
I'll just come to that. That's when I returns for the period of October 2017, I submitted my returns. Then the portal itself made a auto reversal of that amount. I did not come to know about it. When the audit pointed out, I raised a ticket. Audit pointed out as late as 2022, 10/10/2022. Then I raised a ticket on GSTN. GSTN allowed me the permission only in 2024. The moment they gave me a permission to correct it, I filed my GSTR 3B and got it corrected. Before the appellate authority also, I submitted my GSTR 3B return. If your lordship turn 36, page 36 that the appellate order, clause 6.0, I have carefully gone through the facts of the case, the issued order, submissions made by the appellant in the grounds of appeal. On perusal of appeal documents, I find that the appellant has filed the instant appeal in offline mode, which has been received. I note that the appellant has filed the instant appeal enclosing therewith a copy of DRC 07 dated.
What do you say about it?
My lord, as per the subsection 6,
True.
he has to file the he has
Yes,
to file the pre-deposit receipt along with the appeal. Unless until that has been filed, that appeal cannot be entertained.
right.
Without going into the case, also appeal can be disposed. On that ground,
Can you, if it cannot be filed, then it is a stillborn appeal. If it is not there, then there is no appeal in the eye of law.
there is no
If there is no appeal in the eye of law, can you decide it on merit?
while going through the documents attached.
Whatever, that means you entertain the appeal.
While going through the attached document,
Please try to understand.
My lord.
If the language cannot be filed at all, then if it is not, then there is no appeal in the eye of law. So you can't make an adjudication.
You should not have entertained this appeal.
Absolutely. Once you entertain the appeal, then also you are wrong. How can you entertain the appeal?
Should not have.
The order from whatever angle is wrong. If it is no appeal at all, then no appeal.
Paragraph 8, he says that.
Paragraph 8, he says that.
Not even I have submitted the GSTR 3B copy of the GSTR 3 doesn't go into that. He has admitted that I have submitted those copies. In that same parameters, the last 3 lines, later copies of GSTR 3B filed on 26/8/2024 and other documents were also filed during the course of personal hearing. However, I note that the appellant has not submitted any evidence towards pre-deposit mandated under section 107 of the Act. So that revised return which I had filed in the portal, I have also given a copy to him. My humble submission is that that can be considered if the appeal is admitted and but without pre-deposit, appeal should not have. So we'll come to page 4, para E. The reason of non-deposit has already been submitted by the petition. Page 4, para E, 6E.
Page 4 of?
Page 4 of the writ petition. Para 6E.
The authority, what he has done.
Not I got in my case, the documents were not there on the portal. So they have given me the documents in offline mode. So accordingly, I was compelled to file an appeal in offline mode because the system did not accept. That's what I have stated in para E. Because the DRC 07 was solved on me through postal agency.
What is the procedure which is prescribed in the law that how is to be done? Because
Not the appeal procedure.
yes, that is 107 I have seen.
Not under section 106 is prescribed.
That is the right to appeal. What is the other?
Rule 100.
Hey, it is not here. Rule is not here. So there is a provision both for the electronic and as well as the physical manual way of doing it. When they communicated to you about the deposit.
Deposit is by way of a revised return I filed. That was after the assessment order.
After the assessment order.
After the adjudication order, the The GSTN people, they authorized me to file on the portal. And thereafter I filed. And at the time of appeal hearing, I have submitted that copy of that GSTR 3B which I have filed on the portal. And he has accepted also in his order that GSTR 3B was filed before him. Let's if a lordship turn to page 35, last two lines.
Where is that for? Where is the for? GSTN?
GSTR 3B, my lords.
Yes, where is that?
It's not enclosed, my lords. You can find it. Now the last two lines says on 2/8/2024, an email intimation was received to reply.
There is, it is a prescribed form. It is a prescribed form. Where do I get it?
But that is filed. The appeal form may not filed in page. Page 28.
Where is that? Very close. GST. GST 3B.
GSTR 3B.
No, my lord, that's the appeal form.
GSTR 3B.
No, GSTR 3B are not enclosed.
Sir, you have filed GSTR 3B.
My lords.
How it got a so far as the pre-deposit to maintain the appeal is concerned? How this GSTR 3B has any impact at the time of filing an appeal?
That is stated in page 35 minutes. Take your
No,
lordship.
how it has got any correlation? I'm just asking that you are taking advantage of belated generation or furnishing of this particular this GSTR 3B,
That's a revised return.
right?
Yes.
How it has got any impact or relation so far as the filing of and redeposits are concerned? Because the assessment order has already been made, it quantifying a particular amount which you are supposed to pay. Only thing is that maybe this may be the criteria showing that what you have already deposited, because I've seen the form, it shows that it's an auto-generated. Whatever you have deposited will be reflected there.
Whatever was deposited.
Yes.
In November 2017, for the period of October 2017, that amount got auto-reversed.
True, I understand.
When I filed a revised return, that amount was again set forth. So that amount after the assessment and after my GSTR 3B was filed, no more amount existed to be paid. The demand which was there, that no more existed to be paid. So when I filed the appeal, it was only my case.
That is in relation to a merit of an appeal that you sow, but so long that demand stands, are you not liable to deposit it? Are you not? What is your stand?
Unless until 10% is deposited, cannot be admitted. After admission of the appeal, during hearing that all these facts can be considered by the appellate authority.
That's what. What your lordship said most probably is correct. That the demand stands, even if I have rectified my papers, the demand would stand.
Mr. Mahanti,
Not what I'm submitting.
our difficulty is earlier it was entertainment. So we were passing orders to take into consideration this TDS amount earlier under VAT regime.
They accept that.
TDS amount towards adjust towards 20% pre-deposit. Now it is filing.
Not what I'm submitting.
Now the language is filing.
Because
I'm stuck with my own judge. Telling you because over there I have.
Not I concede that. What I'm saying is because of some ambiguity, I have not been able to pay. What I suggest is let the appeal be restored. I'll redeposit that 10% of that demand.
Because it has to be deposited at the time of filing of an appeal.
Well, not at the time of manual filing or appeal, that facility was not there.
What facility?
Not that payment. The system did not accept that payment also.
So kindly have a glance to the page 29 of the writ petition.
When had you filed? Appeal?
This was 24 months.
24.
Hello.
By then, I think by then entire appeal process was streamlined.
Hello. But still manual operation, manual filing was accepted.
The point from the section itself, it talks about both. Subject to certain conditions that manually you can file.
Not a time limit, but some time may be given, 2 weeks time may be given to deposit. And then let the appeal be restored and disposed of on merits.
There we are stuck up. We are to some extent is a sympathetic say, but still the law that really comes in the way is troubling us. What to do? What to do?
Lord, sir, if he decided to dismiss the appeal on the basis of this, then at least a notice was necessary.
No, my lord's view is at the time, because of this language,
My lord, in that case,
your filing is not a filing.
my lord,
So if we allow now, we go 4 months.
No,
So
no.
can we?
my lord, if it is not a filing, they have admitted my appeal. They have numbered it.
Maybe.
They have fixed it for
Suppose if
final.
the wrong is committed, does the wrong creates any
Wrong has been committed. The wrong has been
indefensible
committed.
right or a vested
No,
right into you?
Wrong has been
That-
committed by them.
They cannot do that.
My lord, had they dismissed my appeal at that stage itself, I would have come in a writ petition. Now, my lords, I don't have a right to.
No, we are
also.
saying that though we are, but the laws are so stringent what we can do. That is the where to
With this sort of an appeal order,
where to go out of it.
Relief before the tribunal. No.
Yes.
With this sort of an order, I don't get any relief in the tribunal tomorrow also. Because this is a summary rejection.
Brother, I got to say.
Now, Mr. Mishra must have. This,
The entire problem has been aroused because he has filed the appeal.
No, for a long time I was not. I'm not on the bench. So
Because on online filing, your lordship, without payment, without deposit,
It will not accept.
portal will not accept.
Oh, I understand, sir.
Exactly.
What do you
the
think?
manual you have accepted.
It was accepted,
Yeah.
but it was not preceded by a deposit.
Your lordship.
The difficulty is that there are two things that one is a presentation and another is a filing. It was merely a presentation.
Your lordship. As like as APL 1 and APL 2 in online portal. Once APL 1 provisional issued and after submission of all
But the
complaints.
difficulty is
within a week
any
it-
order of the division bench in this regard.
No, your lordship.
Here the appellate authority has proceeded.
That is the wrong
He has
committed.
accepted and he has recorded personal hearing was
That
afforded.
is the wrong committed because there is
No, that is because this is a dead letter. It can't be. It's a dead made alive.
But as your lordship.
So in
already
both
shown-
the ways it has to go, but the difficulty is not in your to his benefit.
Not in some cases.
We can set aside the order, but we have to say that there is no appeal at all.
Then
Then it will not go to your benefit.
My lords, on the basis of a Supreme Court direction, the Government of India issued a circular in case of some cases of manual filing, where they said that pre-deposit should not be asked for.
So show us show us why you are hiding it
It's not hiding.
in your. You have this. We are asking for a document.
There's in some identical cases, my lords.
Please look into it. What is this document? I don't know.
But this was
Because it says that it will be treated to have been filed in the last.
because of some technical glitches at that point of time at the nascent stage of the GST coming into force. Some tran 1 and tran 2 were not being.
Look at it whether it has still in force or it has been superseded.
Philco was section 16. Philco. Section 16. 2. Supplier has not uploaded. So in such cases, this was dispensed. Filing was.
We have not applied.
In 2023. In 2023, it has been out.
We have not, state GST has not applied this type of notification till date. Why? We have uploaded each and every order. No manual, we have not accepted any manual filing.
No manuals.
State
Not-
GST,
no.
state GST has not a single appeal has not been accepted. I can undertake.
State GST, the Commissioner, Mr. Sanjay Singh, has issued a circular wherever manual orders have been.
Manual orders we have not passed, only the
Manual
circular
orders-
has been issued, so with great
Circular has been
respect,
issued by the, and I have filed a manual appeal. I have filed.
against investigation, enforcement,
No.
enforcement
No,
129
Mr.
appeal manual.
You just go through it, you just go through it, take an instruction and then come back. We'll have other discussions.
Manual appeal.
Enforcement.
By enforcement.
You can draw, that is what I'm saying. This is what.
Both Mishras.
Both
Mishras.
As far as my knowledge goes, this notification will not be helpful to my respected senior.
Both Mishras.
If it says about, because it talks about a particular case, my brother is more acquainted
In that
with
particular
that.
case, this notification.
No, can't be.
That is.
Analogy.
Because of the problem having arisen in that case, this decision has taken.
Your Lordship, section 16(2)(c), Your Lordship.
Or whatever, let us
that
see.
Supplier's return, supplier has paid the tax on that dispute, on those disputes.
But it
this
talks
item-
about the filing of the manual appeal and then dispensation. That is what is
My
there.
malad
That is.
But it is, the GST statute is in such a way that you are rendering the assessees of genuine, see, in 2024, you have allowed them to file a revised return and demand subsists, and revised return he has filed. Now the demand is nil. So where will he go?
Your Lordship,
What would be the
That is
forum?
what we say,
peculiarity.
to some extent we are, but
Peculiarity.
because of this, we are stuck up.
We'll take it soon.
So on the one hand, you argue that 226 cannot cover that extent. On the other hand, you make him remediless by virtue of this, and you have allowed after assessment.
This
6 or 7.
required to be verified
Very strong.
because it cannot override effect on the statute.
Come on, 7th May.
With my lord's kind permission, my lord, 107, you lordship of change, my lord. 107 speaks of filing of both boards. Electronic as well as.
No, that I have seen.
Yes. Because for that, my lords, there is a provision there in lordship 107 empowering the commissioner. If commissioner wants that filing of appeals shall be exclusively on, he has to notify.
Absolutely.
Here, there is no notification our state by the commissioner.
Yes, sir. We have not
There is
issued
no-
any note.
My friend will agree with me. There is no.
Yes,
So
sir.
therefore, it is still today left open to the assessee either to go for manual or by electronic.
No.
Mr. Sahu, that is the issue.
Your Lordship part already gone through.
Let us see, in this case, we do not intend to go so deep. The fact remains that they have accepted the manual filing of an appeal. Now they entertain the manual filed appeal and disposed of. You can definitely say that you have permitted him to file an appeal.
Correct.
Then we can proceed. Now what can be done?
108
We are concerned with that.
Rule 108 clause B says that.
Had they deny the manual filing, then I can understand whether it is permissible or not. But that you permitted it, you entertained it, and then you dismiss. So we will not go into that. Notification is there or not there. It is up to you. It's your why you entertained it.
Once it has been, permission has been granted.
Absolutely. Then let us see. Come on.
Mr. Whole difficulty is you have allowed him to file revised return after assessment.
Absolutely.
So in a way, he has that revised return also you cannot deny, or you have not.
He got a fresh life. Practically to liquidate whatever.
So can be considered
So
by the appellate authority.
how will he get the benefit of revised return which you have allowed
That's true.
after assessment being done
This is what
and lapse of limitation period? Unless you give some discretion on the authority concerned, any authority, maybe higher authority. So how can you deny the entire benefit of his own returns?
yes.
On this peculiarity, it can be said.
I know, that is what I am thinking about it.
Your Lordship.
Please first take care of that. I already indicated to him that so far as we are with you, because we have seen the plight.
Because the waiver.
But the law is, as it stands, really stuck us.
Man,
That is what we wanted. Take care of that. you just take it that whether we can go through that.
I'll take.
Yes.
Item number 10.
10 euros. Yes. May I pray for an direction? I don't know.
Why? How can what is this opposite party number? Who is the opposite party number 5?
No. This opposite party number 5.
He's whatever, he's an employee or yeah.
He is an employee.
Correct. I wonder here, to be very frank, that the mandamus of this nature can be sought. That he should immediately be put under suspension, he should immediately be sacked from the service, should immediately be terminated from the service. Whether a writ of such nature lies, I wonder. I have not come across in my career both over there and here. You can ask, if they are not initiating any proceeding, you can ask that we'll have to initiate a proceeding, take a decision. What is this? Immediately suspend, immediately terminate mandamus. The court will substitute itself into the place of a disciplinary authority and will decide everything here.
Confine my prayer to prayer number 1.
What is this prayer number 1?
My prayer.
Direct the state government to immediately suspend the opposite party number 5. What is this, the prayer?
My prayer is only.
Have you initiated? Have you initiated, madam?
Not the first time. Take instructions.
He has raised a very serious issue about the public money and the irregularities in dealing with it. Huh? You take instruction. The serious allegation as to the illegality in utilization of the monies and accumulation of an asset disproportionate to the income was raised before the authority against the opposite party number 5, but no response is made as of now. Feeling aggrieved by the inaction on the part of the authorities, the present writ petition is filed for a direction to conduct an independent and time-bound inquiry into the financial irregularities, disproportionate assets, and the corruption allegations against the opposite party number 5. The counsel for the state pleads for an accommodation to take an appropriate instruction. Let this matter be listed. Second week, May
8 May. Item 11.
May. The last hearing was also direct to the state council take instructions on.
Lordship, I received instructions that on the self-same grounds in the same period, an inquiry was caused by the Honorable Locality, Your Lordship. And an inquiry report was furnished to the locality, and the proceedings of the locality have now been stayed by this Honorable Court in WBC number 40657 of 2023, Your Lordship.
Local youth proceeding is a state.
Yes, Your Lordship. Further proceedings in locality case number 415 of 2022 has been stayed by this Honorable Court in WBC number 40657 of 2023.
Honorable submission is different. Like a case which has been filed by the another person who is after here.
If it is somehow overlapping, then you file your counter.
Yes, yes.
Yes.
Yes, I am appearing for the appeal for number 6. Who is
Hearing is recording of the name. What is the here? It's appearing is recording of the name in the first date of whatever is.
Mr. Pun has the the subject that she was yes. How many days? 15 days? No. 2 weeks. 2 weeks. If I got so December month, we are appearing for opposite part number 6. And the text of file on the other opposite part number 6. The registry in course of the day. In course of the day, you file the wakalat in the registry. His name be reflected in the cause list. Mr. Srimanta Das. You are appearing for opposite part number?
4 and 5.
4 and 5. Vigilance Department.
Senior Standing Council Vigilance.
Senior Standing Council Vigilance. Srimanta Das. For opposite part number 4 and 5. Yeah, you want to file any response?
Yes, ma'am, it's fine.
You may file response within the time stipulated as a bit. You also.
Yeah,
समझते हैं response to all the this matter
12/5. 12th May. Item number 12.
Item 12.
Item 12.
Item number 12. Item number 12 kindly taken up next week, my lord. Next week, my lord.
What should be filed in counter affidavit also?
You have been served with the counter?
Mr. Maji.
Yes, my lord.
You
I received copy.
You received
yes, my lord. I received a counter, my lord.
What do you say?
My lord, I am not ready for today. Can I taken up next week, my lord?
After vacation.
Very good, Lordship. The circular was for constitution of 48 RI district in the.
That has.
Place was not mentioned. They are insisting that it should be in this place, whereas the subcommittee on site selection, they have selected the RI building to be constructed in another village. And the construction has already started. It was more so because there was no butcher or extra land available there. And the distance and road connectivity and majority of the population, it was more convenient to build that office there.
File your rejoinder if you want.
My lord.
So how soon you will file your rejoinder?
Yes, my lord. File rejoinder, my lord.
How soon? When?
My lord, next week, my lord.
Yes.
Mr. Jayanti Majula, the petitioner has asserted to have received the contract filed by the opposite parties. He seeks a week's admission to file his document. Let's just matter.
19th June.
19.
Item 13.
May it please your lordships. Lordship, the prayer in this writ application is for a direction upon the respondent, especially the Odisha Power Transmission Corporation Limited, to issue Form C. Because the interstate purchase has taken place, and we have sold them certain goods over a period of 3 years, 15, 16, 17, 18, 15, 16, 16, 17, and 18. And in order to avail concessional rate of tax loss, they have to issue a C forms. They have issued a C forms for 15-16 and for 17-18. And for 16-17, partially they have issued. And we've been writing to them to issue C forms, but no forms are being issued by them, Manoj.
What are you doing? Why you are not issuing?
No, Your Lordship, no allegation against us, Your Lordship.
This
It is the allegation against opposite party number
Notice will have to go to respond
Have you
number 2.
served the,
This
have
rate
you
may not be
served?
maintainable. This rate may not be maintainable because the Ghaziabad, the assessment adjudication order has been passed at Ghaziabad.
Oh,
Your Lordship, the dealer in charge, Your Lordship, he has allegation against the OPTSL Odisha, that OPTSL has not issued C form to him. For that reason, he could not produce in
Under the
Ghaziabad.
Central Sales
oh,
Tax
that is
Act.
the
Your
difference.
Lordship, Ghaziabad,
So his grievance is against that OPT, who
This has
is
to be issued to them.
within the state.
Yes.
So he wanted that why you will not issue a C form when a transaction interstate.
Yes.
Why not? So have you given a notice?
No, so if Your Lordship should kindly see paragraph.
Opposite party number has been given. He is opposite party number 2.
No, see, opposite party number 2. I have been told that you don't accept notice. Notice has to be issued.
CL, whatever. Have you served the notice? Copy has been served.
My advocate on record is there, he'll say.
They will serve them after your lordship's order because.
Oh, you. Then issue notice on it.
OPTCL,
They have a panel of lawyers, so
Panel of
to take
lawyers.
notice to them. To speed post.
The only issue is involved in the instant writ petition relates to the non-furnishing of the C form for the transactions between 2016 to 2017. It is submitted by the counsel for the petitioner that the C form was issued by the opposite party number 2
2-5.
for the previous as well as the subsequent years, but for such relevant period, the same was issued partially. Though the state is, you are representing the state, or
Your Lordship, I am opposite party number 1. State
though
of
the opposite party number 1 is represented by Mr. Mishro, but we do not find any appearance of the opposite party number 2. Stop. Issue notice upon the opposite party number 2. Requisites within
2 days.
within 2 days from date. Matter returnable after. Yes.
Mr. Mohit,
I know.
2 to 5 is necessary or only 1, 2 will do?
Only 2 will do your lordship.
So your description in 1 is wrong, it seems.
Your Lordship, secret.
Commissioner cannot be secretary. Secretary come commissioner is not, never.
Yes,
No, that should be corrected. No, I apologize. It should be corrected.
Leave is granted to the petitioner to correct the description of the opposite party number 1. 1.
On 23rd June. Item 14.
Run by charitable trust,
Exempted. Yes.
Plus, the outcome of processing of return for the assessment 2018-19. Article 143.1 is communicated to the petitioner, right? Annexed 2. I will take a lordship's attention to page 37. Gross. The return was processed. My claim of exemption was disallowed, resulting in tax demand of at page 37 at bottom 4 crores 39 lakhs 01,526 gross.
Correct.
This is appeal. I filed appeal bills before the Commission of Appeals. And the very next annexure 3 bills that I succeeded before the Commission of Appeals, my appeal was allowed. My lords may kindly see the relevant page as page 49 gross. I'm not burning your lordship much into the fact. 49 page is the result appeal is allowed bills.
Yes.
This revenue got aggrieved. Revenue filed income tax appellate tribunal.
Yes.
Because tribunal
The next annexure 4 minutes, page 52, my lords, may kindly see. Dismissed the appeal filed by the revenue.
Correct.
At page 53, in the result, appeal of the revenue and cross objection assessment and dismissed.
Even a cross objection filed by you was
That was
dismissed.
not necessary because it was in my favor. But, as a right, you all may need to file, I cannot do that. So now appeal is of the revenue is dismissed and the exemption disallowed now stands restored mirrors. I am entitled to exemption mirrors. Now mirrors, with this matter could have stopped, recovery of demand should have been stopped, but instead of doing so mirrors, the revenue also preferred was miscellaneous. MA normally they file to rectify if any error is there apparent in the order of the tribunal. Tribunal had annexure files and no, that is no that MA was also dismissed mirrors. So ultimately confirming mirrors restoring back by exemption and there is no demand survives mirrors. That's where these tax stand thus mirrors. At annexure mirrors 6 as page 56, you know, kindly see what has happened. The Assistant Commissioner of Income Tax Exemption, you also kindly see the caption, subject, giving effect to orders, page 56 minutes.
Give effects to the orders,
Yes.
letter for verifications and order of CIT appeals.
This order, this letter issued on 19/2/2014. By this time, the order of Commissioner of Appeals has already been superseded by the order of tribunal. So what is Virat's operative order? The order of the tribunal, Virat. So, and that also dismissing revenues appeal gross. So whereas there is no need of giving effect to anything because now by virtue of the order passed by the tribunal, the demand doesn't survive. Exemption is available to the petitioner. There is no demand as such. But what he did, he created a new issue by giving effect to the order, allegedly to the order passed by the CIT appeal, saying that under section 11(6), referring to that, he said in the light of the above section, the aforesaid depreciation of 3,01,05,917 shall not be allowed and added to the income of the assessment. If you have any objection regarding proposed addition, please submit a response with supporting documents electronically in e-proceeding facility. Before 26.2. Even if it is not required to respond, because may I submit with great humility, this letter which is issued on the garb of giving effect to the appellate order, doesn't institute any of the power available under law, the exercise of power itself, this is a nullity, because you cannot give effect by creating a new issue and asking the assets to respond to this. Despite of that, I still responded by the annexure 7 at page 858. Our detail is there, reply is there. And then he passed an order at page 60, that is annexure 8, which by also now kindly see. This purports under section 251 read with 143(1) of the ITI, and the issue which he has raised in the letter which I was referring to, he confirmed, and based on that, now he raised a new demand of 1,62,350, which you will find the last table at page 61. So this could not have been said to have been giving effect to appellate order by a new issue which is unknown to law. Never come across. I was surprised to find this, but this has happened. And the section which I referred, if you are to section 251, I have seen at least 100 times. Section 251 speaks of the power of the Commissioner of Appeals in deciding the appeal arising out of as order of person. That he has power to enhancement, he has power to confirm, he has power to annul, or power to set. These are powers available to him. So by virtue of 251, this order which he claims to have passed could not have been there. And so also 143 was an intimation, which I read you before also is a processing outcome. So the very the source of power said to exercise to pass this doesn't survive. It's a nullity because. And I am reminded of one judgment by Lord where our 54 Supreme Court in
Kiran Singh's case.
Yes. That was reaffirmed by Supreme Court in 2017 in Gurman Singh's case also. Very same ratio was repeated on the Supreme Court. that if any
Inherent lack of jurisdiction, then it is a nullity.
and when can the order or action can be taken to a nullity bill, that also is mentioned there. So here, therefore, when there is no power available, so any action taken by a statutory authority acting on a statute must be. And now what has happened? Before my friend respond, just 1 minute. What has happened? There's a rectification. Again, I prefer rectification, saying that while passing this, he has considered my reply now. He has not referred. He has only dealt with without reply. Had he considered reply, perhaps this would have been high rectification. He said the rectification order at page 64. No, there is no rectifiable order, so this is also dismissed. So that ultimately the new issue which he creates now, by Annex 66 or Article 5, the demand notice say that demand 1,33 lakhs also. Now by Annex 12, Article 5, a series of bills, series of attachment notices. Your Lordship kindly see Commissioner that is available bills at page bills. For a 79, for a moment, my Lordship kindly see where I stand. This is page 70, Annex 13. Bank account of United Bank, Oriental Bank, Axis Bank, Punjab National Bank, Indian Overseas, all banks. It's an education institution. I'm not being able to pay salary to my employees. Very difficult. One day also. So this is how bills I have been landed. I left to your Lordship bills to kindly. And I have, of course, filed that again. I have filed against an order in audit. And now only I pray, Milos, two things, Milos. If your Lordship go by Kiran Singh's judgment, the entire thing, even at the stage of execution, Lordship knows. Once it already
There are two ways of doing it. Either we have to entertain taking into account that you have already exhausted a remedy by way of an appeal.
Correct.
So whether the High Court should go to that extent. And the second way is that we invite the hearing of the appeal and say that within 1 month or 2 months you have to dispose of.
That's right. I also fully agree with Lordship. Now that, but one thing, at least this should stop. Recovery should stop. With this background, at least, consent will never permit because I am.
That the appellate authority can also pass an order of stay of the demand.
Now, there is no provision available, but
that is 64 Supreme Court is there. If you have a power to annul the order, reverse the order, then the power to pass interim order is also.
That is respectful. Not
Income Tax Act.
But incidental ancillary power.
That was under the Income Tax Act. Itself, the same law.
Yes. So therefore, your Lordship also, your Lordship can, under the peculiar circumstances, stay in recovery by Lordship direct disposal of it. That can be done.
What is the latest judgment?
Judgment on
Supreme Court on this.
Peculiar, never happened.
Peculiar means there is a recent judgment.
LG Electronics, all these cases are there.
2025 volume 2 or 3 Supreme Court cases. Harish Jain's case of Justice 3-judge bench of probably Justice Vikramnath authored that judgment. The similar point arose that if you approach the authorities and the authorities does not have the jurisdiction or lack a jurisdiction, then mere submission to a jurisdiction does not confer the jurisdiction on that particular authority to decide it. And it is a nullity, then it is a nullity for all time.
Exactly, nullity for all time. Even I think your Lordship 69 Supreme Mohammed Qureshi case, after which 73 rules by tribunal rules was that was promulgated, it was not. Honorable Supreme Court said even if appellate authority has no statutory power, but it has ancillary and incidental power to deal with state application.
That is what I'm saying.
Exactly.
That's a very off-quoted. The first judgment is only 4 paragraphs judgment of the Supreme Court was there. It simply says when it has a power to reverse the order, set aside the order, confirm the order, then it has a power also to pass an interim order.
But because of the peculiarity only,
despite no provision there in the act that was there. Anyhow, this is the latest judgment of this Harish Jain. Yes, what do you say, sir?
My lord, the petitioner has neither filed a stay petition also here, nor claim any objection in this petition.
I am again saying if the jurisdiction is found to be conspicuously absent, there, this is that judgment. It says that mere participation there or mere approaching that authority does not, that he cannot raise a jurisdiction point. If it is complete lack of jurisdiction, then in that event, there are three jurisdictions. One is a pecuniary, one is a territorial, or one is a plenary.
Correct.
If it does not have a plenary, then it has to go. Pecuniary and territorial can be waived. There is no difficulty. But plenary or inherent jurisdiction, you can't. You got it?
Yes, sir.
What is 25, 2 or 3 SCC?
Citation I'm getting, but your lordship, the composition is Justice Sanjay Karol and Justice Vikram Bhatt. 24th January 2025. Harshit Jain.
INSC number 2025.
SLP number is 21.
INSC must be there. At the top left hand side.
No, it is reported in SCC. You will not get it. That's 2025. Volume 2 or 3 SCC is there. And it talks about that jurisdiction and the nullity. Authored by Justice Nath. Yes, you can say the commissioner, as he says, shows the provision that he did not have the jurisdiction because the tribunal has come by the time he issued a notice. If he completely lacks the jurisdiction, then how?
Take the history.
What instructions? It's a pure question of law. No law, sir. And ultimately, all these stages, it has been held that he is entitled to an exemption under Section 11. The department went higher up, could not succeed. And then usurpation, immediately exercise of power, and then you know that a tribunal is constituted in the meantime. The tribunal was constituted by that time.
No, tribunal was already there.
Already there. So-
This is your income.
So, how assume the jurisdiction?
Judicial indiscipline. Clear case of.
Committee and MET.
Sir, I said to your lordship. Unfortunately, what has happened, really speaking with your case. Another.
Yes, how can you support it?
And then the direction we given for the, tribunal, the matter is subsidized.
Tribunal subject. What do you say?
CAT. Appellate authority.
Demand has to be, because the prima facie it appears too. Prima facie it appears, because the order is per se without jurisdiction. How can it be done? Brother? Cannot be done. What? Right. Yes, 2025, volume 3, SEC, page 365. This is, yes. I was having some 2 or 3, that's why. Yes, sir. What to do? You want to ponder upon the thing? Then we will fix it on 29th. We can give you a time to think about, but should they have attached already?
Exactly, yes, that is the problem here.
Have been really.
And fixed deposit have been lien marked. All bank accounts here.
Remarks means they have encashed it in.
Legal mark means put on hold.
Oh, that is put on hold.
My lord. And all banks you not saying. Draconian, they never have seen.
Take the choice of words.
Because draconian, Mr. Sahu is with the.
No, sir. This, what do you say, Mr. Kedia? This can't continue like this.
Next.
Can you wait? You have waited for such a long time. They will not take any further step for encashment.
It is not for them, it's a bank mirror.
No.
It has to be not come to my rescue. It's a bank mirror, not my friend mirror. Had he been there, your lordship always say, yeah, you take care of. They do take care of.
No, only thing is the encashment of the fixed deposits and the remittance. I am concerned with that for the timing because this attachment order is passed long back. So you have suffered it. So we are just thinking of 4 or 5 days to wait and fixing this matter on 29th. Because I have judgment, so that is what I just wanted. I do not want to put him on surprise. Can you wait for 4 days more? Yes.
Can I pray for with little top of the list so that can be.
Yes. In the first or two matters.
Yes.
Yes. Please go through that, Jackie. A point of nullity because of the complete lack of jurisdiction is raised in the instant writ petition, despite having exhausted the statutory remedy provided under the Income Tax Act 1961. The senior counsel appearing for the appellant submits that the moment the order is per se void and or nullity, it should not be permitted to survive, and there is no fetter on the part of the courts even in collateral proceedings to declare the same. The plea of nullity is raised because of the initiation of proceeding by the Commissioner of
Assistant Commissioner of Income Tax.
Assistant Commissioner of Income Tax Exemption, despite the matter having traveled up to the tribunal stage at the behest of the department. Stop. We find a substantial force in the aforesaid submissions and permit the counsel appearing for the department to follow the same and argue the matter on the next on the day when this matter would be listed next. This is the matter on 29.
The amount is 23 lakhs and odd.
Though demand is 1,31, but attachment is 23. Probably that is not exactly 20%, not exactly. But somehow I also don't know what the logic behind it.
Yes.
Item number 15.
Mr. Mahanti, you get ready because we will pass the order. We will not delegate him to avail that. Perhaps, maybe, subject to.
Yes.
Item 15.
Well, in this way, extent, the sort of power of the commissioner to revise an assessment order is being challenged. Well, so far as to invoke the power under section 263, that so much of power is given. The order which is to be revised must pass a twin test. One is it must be erroneous. The second one is it must be prejudicial. If it is only erroneous, not prejudicial, it cannot be revised. Now, my lords, here, my lords, the assessee petitioner filed a return so far as 1718 is concerned in the year 2019, my lords. Now, my lords, the return, that was the date, my lords, and 28th of November 2018. He filed a return declaring a total income of rupees
23 lakhs and odd.
Yes. Then this year 1819 was subjected to reassessment, that is escaping the income. Then, my lords, the assessing officer, lords, you will see the assessment order which starts from 85, page 85. He made inquiry, hold hearing with made inquiry, submitted the documents, verified the documents. Then at page 88, relevant pages at 88, also will kindly see. Para 3.4, reasons for inference drawn that no variance is required on this issue. In reply to SCN dated 14th of March 23, the assessee has by response on 19th March 23 completely refuted the transaction with the said individual entities.
Sir, no, this is a case of a differential between the circle rate when you sold the property and the consideration which you claim to have received or paid.
My lords, I am coming here.
So now
I'll answer. What is there, my lords? What was the purpose of reassessment was that there were two sell deeds. That one which I sold, which was sold as a power of attorney by me to two persons, that was the subject matter of reassessment. Then how the assessing officer held like this. From the copy of the sell deed, may I phrase your
I could not get it. This is something very unique you said, that as a power of attorney you sold. Then who is your principal?
My principal.
Because you are an agent.
Yes, yes. I am the agent.
So who is your principal?
My principal, I have enclosed the copy of the sell deeds. I have enclosed the copy of the sell deed matters and as well as the power of attorney. That is Annexure 10 and 10A.
No, where the consideration money went? In your account or in the account of a principal?
In their account. I have not got. And now, what happened, my lords? After due inquiry, the assessing officer concluded that so far as the sale that plot is concerned, is not the subject matter of the reassessment in this case. And therefore, my lord, the assessing officer accepted the return and no demand was raised. Now, after the passing of the order, despite the fact that there were inquiries, there were investigation by the assessing, the CIT, Principal Commissioner of Income Tax, invoked the jurisdiction conferred under Section 263 of the IT Act by issuing a notice. Lordship will kindly see at page Annexure 11 at page 117. Then, my lords, be pleased to see.
Yes, yes.
My
Then,
Then I file my reply, that is Annexure 12. And at this stage, this Honorable Court. And during the pendency of that repetition matters, the CIT passed the impugned order by saying that there has been no proper inquiry. That your lordship will kindly see.
what is your stand? It's a change of opinion or
No, it's not a, because
it's not a case of a change of opinion.
No, my stand is, my lord, this does not warrant the Commission of Income Tax to exercise the jurisdiction under Section 263.
Yes.
And I have got certain judgments, some judgments for your lordship's perusal by the Delhi High Court, one by the Delhi High Court was DJ Housing. I'm just submitting them. That once the assessing, because the commission has just DG Housing. That should be a candidate. I am bringing to lordship's kind notice para 17 matters. Lordship may kindly turn to para 17. This distinction must be kept in mind by the CIT while exercising jurisdiction under Section 263 of the Act, and in the absence of the finding that the order is erroneous and prejudicial to the interest of revenue, exercise of jurisdiction under the section is not sustainable. In most cases of alleged inadequate investigation, it will be difficult to hold that the order of the AO, who had conducted inquiries and had acted as an investigator is erroneous without CIT conducting verification or inquiry. Now here, I may pray your lordship to see the impugned order, para 5. The CIT says, page 33, lordship may kindly get, see. From the above, it is evident that the AO has failed to carry out inquiries as warranted by the facts and circumstances of the case, and assessment had been completed without examining all aspects which were required to be looked into for determining the total income of the assessee. The order has been passed in perfunctory manner. The AO has not applied his mind properly to the facts of the case. Despite the fact, my lords, the case was selected for reassessment, was reopened, and inquiries was held. Assessee was asked to give his explanation. Assessee had submitted the documents, and after due verification, after due inquiry and investigation, my lords, the assessing officer came to the conclusion that the property is not the question of this assessment, and accordingly he accepted the return. So where is the question of erroneous? The CIT cannot substitute his opinion or her opinion. It is the domain of the assessing officer. Only if it is not in accordance with law, then only you can say. I will give another judgment of the Bombay High Court, that is also the same line. And the Bombay High Court Lordship, I'm just giving for your Lordship's time. Perusal. The CIT, with great respect, my lords, she did not make any inquiry or verification. May I
In a benchmark valuation because material distinction difference.
May I
Yes, it is clear to the notice. And the
Yes.
You give a response. While your counter. The difficult proposition. We will consider you on the ground of erroneous decision.
Right.
It's a difficult proposition. Let us see.
Right.
File how soon? 2 weeks. 2 weeks. Matter to appear after 2 weeks.
Yes. Item 16.
May I say for the
For the time being, let us see. Don't worry. Yes.
may I know the date, my lords?
7th May.
7th May.
Me. Yes.
Item 16.
I mean, pardon, item 14 that will be indicated to be listed at the top of the list. Item 14.
We have already passed an order. It will be there already. It's called the next.
Item 16.
Covered matter. That is non-constitutional.
Oh,
Non-constitutional.
so we are keeping this matter alive for the time being. 10%. We are keeping this matter alive. It will not be disposed of. Yes. Leave the matter. With this. Yes.
Item 17.
May I please your lordship. Lordship, I am on BC.
Yes.
May I please your lordship. Lordship, this matter is belongs to army. The petitioner is a retired person from army, and there is a similar matter pending, lordship, that is coming on May, and this matter is.
Give the number so that it will be tagged with that.
Yes, your lordship. I will.
Say whether it is maintainable before the High Court. We'll see to it. Which matter is there? Other matter?
Lordship, read petition 30725 of 2024. I have mentioned this in at para 1 of the petition, at page number 3.
Yes, let this matter be listed along the said matter. When that matter is directed to be listed,
Lordship, on May 6th. 6th of
yes,
March.
it will list along with this. Yes.
Item 18.
Page number 3.
16, 17, both are agent to
Obliged.
Yes. This is for non-filing of the return. So, thanks. Well, next.
in the RC cancellation matter.
Okay.
The issues covered under this Euro. Yes, select from 2 and
All 3 cases. Yes.
Item 20.
Lifting of 180 ml.
Yes. Have you seen that?
No.
Whose matters are posted from 5th of May.
Yes, MCQs matter. I think minimum currently 180 ml. Yes.
We are enjoying an interim order, Your Lordship.
So, same order.
Same order.
That is that this one. We do that.
Yes.
2021 7.
Yes.
Item 22.
Item 22, Lordship, I am appealing for the respondent. I have filed caveat. Copy of the appeal may be served to me.
Oh, why don't you serve? So,
Lordship, time may be given. I need to go through it and file.
how much time?
2 weeks, 1 week at least.
What is the good name?
Mukesh Panda.
Mr. Mukesh Panda appears by filing a caveat and submits that the copy of the read appeal.
Other tax appeal.
Yes, the copy of an appeal is served upon him. The appellant has served the copy in course of the day. Stop. Mr. Panda prays for an accommodation to peruse the amendments made therein. Stop. In view of the above, let the matter be listed after a week. Give a date.
8th May.
Yes.
8th. Item 23.
My lord. Since my lord friend, Mr. Mahanti, who is the curator, he has already appeared. We have already served a copy of the appeal petition.
Yes.
We will go through. And along with that, IA copy also go.
What is?
There has been delay of 67 days in approaching your lordship in this data page.
Yes, what do you say? What?
He is asking for passover.
At this hour.
Can you give a copy to him?
At this hour.
Call him, it's a section 5 application. Call him. Condonation. Go and call him. 5 minutes. 3:45. Next.
Item 4.
When before my lord looks to go in this IA, there has been delay of 886 days.
What? You want to file for counter?
Similar case, inferring the decision of Supreme Appeal Court, and one data Odisha and Sarva Mandir is that similar things have already discussed by this one. And similar, it's a delay by
Delay, we are concerned, sir.
yes, sir, 2.6 more than happened.
So what do you want, sir? Would you like to file?
Delay.
Yes, sir.
Would you like?
More than 2.
You wish to object?
Yes, sir. I will.
So file your.
Have you filed objection to IA?
Yes.
You have filed objection to
No,
IA?
I have not filed. Only I am asking in 9:30.
So counter, how soon? Counter affidavit by what? Give me, how soon? 2 weeks. Matter to appear immediately thereafter.
12.
Yes.
Item 25.
If there is any high delay, 303 days.
What do you say about the delay?
Filing my objection to the
Counter? Limitation? Have you served the copy?
I'm just serving.
Oh. Serve him a copy.
Yes, I will.
What do you say? You want to?
Also just now.
303 days.
Yes.
That is what is the
300 days.
the counter application for condonation of delay is filed by the respondent. Semicolon, the copy whereof is served upon Mr. Das in open court today. Stop.
Can come next week.
When?
Any day next week it comes up.
Mr. Das, please, for an opportunity to go through the said counter affidavit. Stop. List the matter.
Keep the memo.
Yes.
Item. Item
5. 15 course of the Jan.
All regularization matter, you won't do that. All regularization matter, you will come in writ appeal and you will not regularize.
Yes, call the
Item
name.
26. Item number 26.
There is a delay of 237 days.
So then service notice?
No, notice.
Notice. 3 weeks.
Item 27.
There is a delay of 37 days.
Who is appearing for that? Have you given a service notice?
State is not a party.
So notice 3
Notice
weeks.
in IA.
Notice in week.
Item 28.
28, my lord, there is a delay of 170. And I have filed another application for impletion of parties because there were 16 petitioners in the writ petition. We have impleted only one as the respondent in the appeal. So for this,
That application we can dispose of, no services required.
Yes.
That is not required. We can even suo moto can add any party. 20?
28.
28. Which IA you said?
That IA is at flag D for impletion of parties 1852 of 2025.
What?
1852 of 2025.
This is an application at the behest of the appellant seeking impleadment of the left out writ petitioners who could not be arraigned as a party in the memorandum of appeal filed. This is a writ petition, no, memorandum of appeal filed against the impugned order. After perusal of the amendments made in paragraph 2 of the instant application, it appears that at the time of drafting the writ appeal, it escaped to the notice of the learned advocate to implead all the writ petitioners as respondent. And such mistake is not intentional. Stop. There is no fetter on the next part. There is no fetter on the part of the court to implead a person as party in the proceeding. More particularly, when the party who initiated the proceeding before the single bench are required to be impleaded as a party as the decision that would be taken in the instant appeal would vitally affect their rights. Stop. Since they are we therefore allow the said application. The petitioner number 2 to 6 of the writ petition shall be added as respondent number 1A to 1S
1A to 1, yes. Yes.
in the instant appeal. The amended copy.
Amended cost title by tomorrow.
The amended cost title shall be filed by tomorrow. So, issue notice on the delay application. 3 weeks.
Item 2.
2 minutes left.
Item 29.
29, my lord. 29, there is a delay of, I will put the respondent, my lord. Yes, yes. 29 and 30, these are almost the same order. 30, they are supposed to file a copy, serve a copy of the petition. I don't know what is the delay there. No.
29, how much?
30, 382 days. I have filed an objection to that. 382 days.
382 days.
My
Okay.
There is an order of your lordship on 16th 4. The item 29. Sorry, my lord. 6-3.
It was served in the open court today, on that day. Are you ready?
Manjari.
Yes. The only so that my lord's judgment, other bench, my lord, the justice has given me in one my case. I will get that.
Not in a delay.
Yes. My lord, I passed on. In my case, that today I could not visit the certificate to be there. I will give
My
it.
own judgment.
Many combinations.
When you want? Next week?
Next week.
Next week.
I don't writing alone, let my senior
Yes,
friend have
sir.
my copy so that I both the case same.
Yes, in item number 30, record an order. What's your good name, sir?
Samir Kumar Das.
Mr. Samir Kumar Das intervenes at the time of hearing of the instant matter and submits that he has instruction to appear on behalf of the respondent. Have you filed Wakalatnama?
Yes, I filed.
Stop. He further submits that the Wakalatnama has already been filed in the department. Stop. He, however, prays for service of the copy of an application for condonation of delay as well as the other applications filed by the appellant. Stop. The appellant is directed to serve the copy of the application as well as the appeal upon Mr. Das within by tomorrow. Mr. Das is permitted to file counter affidavit to an application for condonation or delay
Within a week, man.
within a week from date.
Yes.
Stop. This is the matter after a week.
Both the matter may be 10. So that. 29 10.
Oh, come.
Item 31.
Condonation.
I am appealing for the opposite party. That I have appeared on caveat. I received the copy and I have also filed my objection to the delay.
You have already filed.
Yes.
Have you served? Have you been served? Mr.
Yes.
Yes,
After
Oh.
serving a copy.
They have served
338 days.
In fact, I am carrying the wrong file. That is why I pray tomorrow. Only tomorrow.
Then on Monday you come.
Yes.
On Monday.
Tuesday morning.
Monday is the
Tuesday. Sorry, Tuesday.
Item 32.
32, my lord.
I have
Island objection.
objection.
In
filing the present.
How much?
230.
Really?
The petitioner is.
You have to file a reply, na? Of the last occasion on 6.
It is valid ID content by
You want to file rejoinder to it?
Sir, petitioner going to return this month, 31st July 2025. And then this matter is only kindly see the page 16 of the petition, the writ of bill.
So we condone the delay and thereafter we hear out the main appeal.
Petitioner is going to return this month.
So sir, on condonation, what you have to say?
Can we read according to order? My lord, I am just reading page and see page 16 of the writ of bill. Sure, first kind.
We can't.
Make
go
up your
to-
mind. Either you consent that the delay should be condoned,
No.
then we will hear out the appeal. Or if you want to contest, then let him place their application for condonation.
I'm contested, Lordship.
So let him speak their application
Yes,
for
yes.
condonation. Yes, what you have said. What is the ground?
It is not filed. On the last occasion on 16th April, this case was before your lordship. That day, my learned friend submitted that he will be filing one reply to our IA within a period of no specific
No.
period has been taken there, but 16th was that order was passed. That he will finally reply.
I'm not, copy not served to me.
No, it has been.
No. Thereafter, after.
Thereafter, another copy after.
So in the by Discord, thereafter.
So what?
I have
My
received.
My lord.
Thereafter, I have copy.
If it
After
doesn't file,
16th.
if it doesn't wish to file,
Then
then
I can't have anything.
you proceed.
I can't say anything.
He is on merits. We are not here on merits. We are on IA. You
Yes.
press your.
Yes, ma'am.
It is your IA. You press it.
But also put the trade and bottle of the petitioner.
There is a delay of 212 days.
13 days.
So, you sure what is the sufficient cause?
We are treated in the IA because of the procedural delays. Actually, after receiving the.
But that is not a good ground.
Sorry, ma'am.
That is not a good ground.
Contempt petition has already filed with 7.
Mr. Counsel, please on his legs. Please sit down.
What is this, Vinay? There is no explanation. You should disclose that how and when the file was moved from one hand to another hand, and then what was the steps taken. Nothing is there.
After leaving media, what do you want to say?
Not when housed in very good ones.
And the judgment of the Supreme Court now, the recent changes.
I understand my lord, but delay has to be explained, this delay has to be explained.
Delays are already deliberately.
Deliberately, you cannot say that. Deliberate, no.
And I told it thereafter, I am first of all, the honorable single judge bench was pleased to dispose on 2/7/2024 by passing the impugn order of disengagement with the direction to the collector, the present appellant number 2, to issue an order of reinstatement within the period of 3 weeks. The said order was duly kindly see page 5 of the objection. Communicated to the appellant after waiting for reasonable period, the respondent being harassed filed contempt number 7313/2024 in this honorable court. The honorable court in single judge bench was pleased to grant 1 month time to state appellant to comply the said order.
Objection.
Objection of this.
My learned friend, this might be paragraph 3. My opinion is paragraph 6. Paragraph 3. My learned friend says that he has filed an objection to the IA. Now he is placing it. He has not given a copy.
Not necessary.
No,
Already 5 copies, your lordship.
Are you see, take the entire file.
And then while he was standing, I asked you, he was saying that I have filed
He
a
had
counter affidavit.
for my learned
So,
friend.
but the copy have you not, sir?
No.
Yes, my lord, I have already
Are
solved my
In terms of the lordship's order,
Court had already served the copy to the state council, state windows.
No, where are you filed? In the counter or in their office? In their office?
Office.
Office, once it is filed, your lordship knows it will be reflected here.
You must have the receipt.
Yes.
You must have the receipt.
The advocate clerk has already.
In the
आपने receipt का प्रबंध नहीं किया?
In the office of the learned advocate general, counter is there. They give you the slip. No? Where is that?
Yesterday, that was the copy. Yesterday.
Serve the copy. He says he has not received.
Don't you have extra copy here?
Extra copy.
You have marked it there. So, and you have given a marked copy.
Your lordship can, I am undertaking that I have received it. I am making a submission in the court.
No, he's.
No, I have already.
Given a marked copy.
The lordship, I have already.
He's a marked copy. I could see from here. Yes, sir.
The lordship, I have already filed the objection copy yesterday, your lordship. But the counter of the HG counter. I have taken notes.
With a long practice, you know that once you file it, you are entitled to a slip.
Slip.
नहीं आप दोनों slip
Provide. The respondent is going to get that.
Objection. In the context of number 7, on 3, with this objects, additional government practice. I have recorded your name to have received. Next week.
33.
Top of
13.
29, top of this. The respondent will be going to retire.
No top.
30.
You should have brought the soft copy, you should have forwarded it to your friends.
Item 33.
29. 29, we are going to retire 30.
After getting our order, they will immediately do the needful.
That's not, I'm just praying for 29.
Item 33.
Each, the IN is the delay for 6 days now. IN on other side. IN, this is the contribution of busy filing the instant appeal. There is a delay of 6 days.
5 days. As pointed out by the.
There is a delay of filing as quantified as the reporter. The perusal of the government's training is the this the concept for the business that the grounds assigned in the instant in the institution with regard to the delay in filing the instant appeal has that would indicate that the appellant was prevented by sufficient cause in not filing the appeal within the statutory period of revelation. The counsel for the state did not seriously oppose their considering the government's made in the twisted application. We are satisfied that if its appellant was prevented by sufficient cause in not filing the appeal within the period of revelation. The delay in filing the appeal is hereby the application being IN under circumstances is discounted. Where is the next application? Any application or not? Then the appeal has to be listed. After service is done.
Service, they have copies of them.
Fresh. So after this delay is confirmed, this is a fresh admission. For admission after 1 week.
Yes,
Fresh admission.
6th May.
Next.
Item 34.
I'm 34. I'm on KV at your lordship in this matter. And I have not been served with any copy of the or any IA for the condemnation of delay.
State is a respondent.
It's a private opposite parties who are in the writ petition. They have preferred the writ appeal, your lordship.
Then appeals in support of the petition. This matter after the petition.
Well, item 35.
Your lordship.
Have you served? Delay application refused.
He has refused to pay.
Who?
Petitioner has refused.
They refuse. Where is the service? Where is the service they related?
No, we have served, but they feel that after admission they will.
Council refused. So notice has to go
Notice has to go on the party itself.
to the address.
So notice to the party.
Yes.
2 weeks.
Only the 30th one of the matter is now listed to the limits in the judge on the 30th one. And personal appeal is.
If can you visualize if your advocate record is that far, you ought to have taken a steps. When there was a refusal from the advocate, you should have immediately sent the copy there. Or would have mentioned the matter to be listed immediately.
Your lordship will have it next week.
Short service, then you'll have to show.
Yes.
Immediately you'll have to file your exits today. Any particulars?
We'll also like to solve then.
Window, search window, search box, edit, search for apps, settings, and documents. Scan off.
OUT
Search
की
history,
अपील
loading.
मेरू OUT की अपील
तुमसे रफ ही जाए
OUT
Yes, sir.
Narrator with scan. Narrator, exiting narrator.
Sound of
Mr. Aravind OUT पे की अपील करती
SC रफ the read petition SC रफ was appeal. The lordship direct we can solve subject to the
Short notice,
Right.
if it is today, matter will appear in the next week. Next Friday.
Yes.
Yes, for the next. There was
Item number 23, the password.
In this case, my lord, during the course of the day at around 12 p.m., 12 a.m., a copy of the writ appeal has been served on me, and I found, my lord, there are two IA applications. I would beg, my lord, your lordship grant me 7 days time so that I can file my objection to both to the delay condemnation as well as the other defect which has been the other IA.
Defect what?
My lord, this the writ appeal has been preferred without giving the certified copy of the order. That is,
They filed an application.
they have filed an application. They have filed an application
For dispensation.
for dispensing it. That is what they have filed. And another is condemnation of delay.
Why you want a condemnation? How many days delay?
Around 90 days delay.
67 days.
The reporter says 67. What do you have to say? 67 days delay only?
My lord, your lordship kindly see that.
Only 67 days
My lord,
delay.
your lordship kindly see the issue involved as well as the offer, the ground they have taken in the condemnation delay petition. Your lordship kindly see nothing has been said. Your lordship kindly
Sir,
see.
if it is not inordinate delay,
And it is your lordship discretion. My lord, I can.
That is what I am asking.
Your lordship just see whether no, not a single ground has.
and Honorable Supreme Court
Yes, sir,
recently,
your lordship.
under 10 days,
Your lordship.
under 10 days delay was not.
If your lordship wants to condemn the delay, that's a different issue. So my lord, the point is your lordship kindly see nothing has been said.
File your opposition, file your counter.
Yes, ma'am.
We delay application only within a week and we are fixing this matter in the.
Other IA and friend pointed out the filing of certificate copy already we have filed. Already we have filed on 28th of March.
So your lordship fix it one week after that.
That I have has become in progress. In which we filed certificate copy.
I'll file the
Let's go
objection.
to the next.
Item number 36.
Item 36, may I be pardoned to submit your lordships? I am appearing on behalf of the respondents. My senior advocate, Mr. Jagannath Patnaik, will be conducting this matter. He has some personal difficulty today. I pray for it to be taken up tomorrow.
That matter we can't assure that it will be taken up tomorrow.
The next week, your lordship, whatever date your lordship assigns.
After 2 weeks.
Right.
Grateful.
Item 37.
It was 23, my landfill was there, the lordship asked an order that he will filing reply to our REA. At the first hour, no general one here. Day after tomorrow, yes, 30th, that content matter is posted. That is why
That he has paid for it to just mention the matter.
yes, I will mention.
Is for 37.
37.
Yeah.
37.
Item 37, the matter regarding examination, written examination for the purpose of recruitment to the post of junior engineer civil. That examination was scheduled to be held on 16/7/2023. Report that some of the unscrupulous persons, they have got access to the question paper and the question paper was leaked. And since they were in that racket, they involved some candidates and some of the candidates all over the state. More than 5,000 posts were there, and for that purpose, application was made. And they have assembled at Bhubaneswar Barguna bus stand, and from there they went to Digha. Digha is a very far away place from here. There is seashore. A hotel was booked, and from Bhubaneswar to they went to Digha, Baleshwar, more than 180 kilometers, and they have congregated there. And the leaked question paper was handed over to the candidates, those who are aspirants, on the next day to appear in the examination. And when all these things are continuing in the hotel itself, police got to know about the fact, and immediately raid was conducted there. And all the persons, those who are involved in the leaked question paper and the candidates, all were arrested on the spot. And everything was seized from them. Question paper, cash transaction, there are checks, there are original documents, all the things, everything was detected. Immediately thereafter, the SP Baleshwar intimated the Staff Selection Commission, for which I am appealing, that the question paper has been leaked, and the report was of the Staff Selection Commission rules for their misconduct for getting access to that proposal. And similarly, also criminal case was initiated against them by the concerned police officer. And in the meantime, what happens? The examination which was scheduled to be held on 16/7/2023, it was rescheduled to 30/9/2023. When it was rescheduled, some of the candidates they challenged the rescheduling of the examination. They say that since most of the candidates have other candidates have appeared, those who are not involved, it should not be cancelled. And some of the candidates they have also challenged the rescheduling. They appear that they may not be allowed to appear in the section examination which was rescheduled. Therefore, they approached this honorable court, and this honorable court took up the matter and passed an interim order that let them be allowed to appear in the said examination subject to final. Accordingly, they are allowed to appear in the examination. In the meantime, the order was passed since the gravity of the matter is very serious. So it should be handed over to the CID crime branch to look into the matter, and the police officer not below the rank of DIG to look into the matter, because interstate racket is there and big huge amount is involved in the matter. Per candidate 18 lakhs they are demanding.
So it has gone to CID or CBI?
It is CID crime.
CID crime.
Yes. Now investigation is going on. And during pendency of this case, a report was called for from the CID crime branch. What is actually what has happened? Affidavit was also filed.
The order does not indicate so. It only says that investigation be supervised by the senior police officer, not below the rank of DIG.
Yes. That is the order passed.
Yes.
And in the meantime, what happened? The second examination was conducted, and they have filed again some of the candidates, they have filed a petition that since we have appeared in the examination, our result may be declared. In that,
the first or second?
The second, those who have
result of first or second?
The result of first was cancelled.
Gone.
First gone. That is gone.
Second to be cancelled result.
Second, there
is no allegation that only thing is that some of the tainted candidates
they have
they were participating.
Participated by virtue of the interim order passed by the honorable court.
So you can declare the results.
Yes.
Withholding their results.
No, others have already declared. Now only yes, others have declared. Now only the candidates, those are involved in the malpractice, their result has been withheld.
Correct.
Now they are before the lordship. And this honorable court said.
And what is the investigation? The outcome of the investigation?
Investigation was in progress. The final list is
No, I just wanted to know what is the purpose of anything has been found, any charge sheet has been filed or what?
Charge sheet has not been filed.
Why? This is of 2023, the investigation.
Yes,
so
then why this is at the base of OPSC? It's a public
Staff selection.
Staff selection commission.
Yes.
You have come up.
I am first.
You have come up.
I have
come.
appeal. Now the final order has been passed in this case, saying that there is a distinction. Distinction has made by this honorable court, saying that there is a difference between leakage of question paper and getting access to the question paper. Order itself, I will place that order. They say the culprits, those who are in the racket, the main culprit, they are interested in the leakage of question paper. They are the persons because they have got the question paper leaked and they have got the question paper. And the students have got access to the question paper. So our rule says that if any candidate has got access to the question paper, it is a misconduct. So no so-called notice was issued to them because they are getting access to the question.
Candidate means what? They are not in employment. They are offering the employment or what? I do not get it as of now.
Students.
They are the candidates for the post of junior engineer civil.
So they are offering their candidature.
Yes.
That does not mean that they will be successful in the examination.
True.
Rule and what steps? The rule will apply the moment they come into the system.
No, if they will involve in the malpractice of copy or other things.
Who will involve? The student?
The
or your employee, existing
not employee. They are the candidates applied for the post. They have applied.
But the rules are there.
Yes.
Very interesting.
Rules are there. Otherwise, they will get misconduct, all kinds of misconduct they will follow. They will.
What punishment you can give?
They will not be allowed. They will be debarred for that examination, particular examination. The candidate will be cancelled.
Suppose if it is cancelled.
subsequent exams also 1 or 2, 3, it is within the jurisdiction of the Staff Selection Commission to debar them from appearing in the further examination.
Reason for challenging this order, the order really goes in a correct spirit.
No, the order says, the distinction was made by the Honorable Single Judge. They said there is a distinction between leakage of question paper and getting access to the question paper. So they say if the candidates have got no involvement with the leakage of question paper, the so-called notice.
What is the meaning of the word leakage?
Leakage means from the press, when it has been printed.
No.
Yes.
Does it mean so?
That has been made by.
Leakage means from anybody who is authorized, who is an authorized custodian,
Yes.
passes on and then open it for many, all or sundry or to some selected persons. That is a leakage. That somebody has leaked the question papers means they have made it open, which did not be opened before the examination.
Exactly.
So that is a leakage.
Leakage.
What is the meaning of the word access?
Yes, but in the present case, what happened? The question paper was leaked in the press itself.
Because it is leaked for an access by the interested person.
Yes. So in the present case, it was leaked in the press where it was printed, and it was brought to Baleshwar.
Is an access. Any person who leaked it gets an access to the question paper. Unless he has an access to the question paper, how he will leak?
We cannot take any action persons those who are responsible for the leakage. But we can take action against the candidates, those who have got access to the question paper. Because the candidates, it will involve in the access to the question paper prior to examination, we can take action against them. But we cannot take action against the culprits, those who are involved in the leakage of question paper.
Rule, I am surprised to understand that there is a rule for that.
Yes, that is a rule. So that is for Odisha Staff Selection Commission rules.
That they are not a star. Anyhow, let us see.
Yes. Rule 18, you consider Rule 18.
Very interesting. Aspect of the common order passed by the single judge, influencer, and after the
What
Yeah,
my brother has pointed out, sir, this is unexpected from the organization, I mean the government organization like you.
The person people, they will involve in the misconduct.
You are arguing something differently, but your prayer shows that you wanted that the entire order to be set aside.
No,
That means the prayer is, my brother has just shown me,
I
that
will
shows that you do not want any inquiry to be conducted by the authorities. You do not want that there should be any attempt taken for leakage. You do not want that there should be no steps taken against who has participated. What does it mean? Setting aside?
We have issued a so-called notice, that is page 10. Page
So
47.
why you sought for setting aside the entire order? My brother will
In
read
respect
for
of
you.
that only,
My
You are-
brother
you are-
will
order itself speaks.
Mr. Swain,
Yeah.
please, it is prayed therefore that this court may gracious be pleased to admit the appeal, call for the records, and after hearing the parties, be pleased to quash or set aside the common order dated fluently, passed by the Honorable Single Judge in WPC and accordingly dismiss the writ application.
Read application.
So, what
They are in the writ application to declare.
Sir, what is the order of the learned Single Judge? Let us see.
Yes, I'm placing.
Huh?
Investigation to be done by the
Paragraph 10.
So investigation. Investigation you want to quash it.
Kindly turn to page 159.
Single judge asked the investigation to continue, that you want to quash it.
No.
That is what.
That is not my grievance.
Sir, your prayer is that.
No.
Sir,
or the order with regard to declaration
sir,
of
how will you
violation.
justify this, sir? Your prayer is to quash the single judge's order, and single judge has directed for investigation to continue and not below the rank of a high official of the police department. And
One of the writ petition was sought to be withdrawn by the writ petitioner.
That is with regard
that did not allow.
That was withdrawn with regard to.
No, sir. Please read.
Yes.
With regard to writ petition number such and such, although the learned advocate for the petitioner in this case filed an application for withdrawal, however, the same was not allowed as this court was monitoring the entire investigation in the said writ petition.
Yes.
Then it says, in view of the affidavit filed by the investigating officer, pursuant to the order passed by this court, the said writ petition is also disposed of as withdrawn. However, it is directed that the investigation which is carried out by the IO shall be supervised by the senior police officer not below the rank of a DIG or police as directed by this court under this order. So this particular investigation to continue under the supervision of officer not below the rank of DIG.
Let that.
And you wanted this entire order to be
actually
set aside, writ petition to be dismissed.
No.
And then the entire exercise will go.
The writ petition was filed only for the purpose of declaration of the result, not for other purposes. Writ petition was only purpose of declaration of the result, not for any other purpose. So investigation that.
Yes. You are arguing on the merit. We are not. We are not interfering with.
No. Let me submit it to be.
A serious allegation of the leakage is given.
No.
Not.
Let me place the order full.
Anything on that.
Paragraph 10. Also, can you see the paragraph 10 of the order? Paragraph 10 of the order is relevant for this purpose.
Yes.
Paragraph 10. Let me place it page 169.
Yes.
That in the aforesaid backdrop, this court permits IO to continue with the investigation with a direction to conclude the same as expeditiously as possible by covering all angles of conspiracies. Then here is the relevant portion. Further, this court also directs the Staff Selection Commission to finalize the proceeding initiated by issuing so-called notice to the petitioners to which petitioners have already filed their reply. I am on that notice. In the event it is found that the petitioners are in no way involved in the leakage of question papers. So our case is that they are not involved. Leakage of question papers. Then
how can be your case? The investigating officer is investigating
our
in a different way.
You also can see our so-called. What is our so-called? Our so-called is page 47.
Sir, you are creating all short of
Let me clarify.
You are creating all short of
Let me clarify.
When an investigating officer is investigating and then found that they are also involved in the leakage.
That
You are trying to cross or make a distinction.
No.
That the
Let me make
and
myself
the
clear.
access
Let-
are two different
No,
concepts.
let me make myself clear. No, I am not clear probably. I am not clear. Let me make myself clear.
He's making
Let me make myself.
he's creating a confusion and not making it club.
Let me make myself clear.
It is better to dismiss this appeal so that the investigating officer will continue.
They are not investigating officers are not.
And nobody should be split.
Investigating officers are to look into the matter in the
What
side.
it is not doing, we are taking a very serious note of it. That since 2023, and this is such a serious question, no reasonable man would accept that in a public employment there will be a leakage or an access to a paper. Man. Why? See, these people should be taken to task. And 2 years period have elapsed, there is no result.
I can't say that there is no result. They must have proceeded something, but 2-3 that is why these difficulties. Digha is in
This
West
examination was conducted for recruitment to this state.
Yes.
It was a state-based examination.
Yes.
It's not.
No, allegation is that the leakage was conducted outside Odisha. They gathered there. That somewhere it is Digha, it is written. It is in West Bengal.
57. Page 57.
Your Lordship may pray, your Lordship may call it.
57. Top. That is probability that
Your Lordship may call it on 30th. In the meantime,
You make initiative proceeding.
We have
You make initiative proceeding under Rule 18.
Yes.
I can understand.
Yes.
The punishment is twofold. You can debar him from participating in that examination, or you can debar him from participating in a future examination.
Yes.
You are preempting the harsher the punishment, then preempting the first punishment.
No, we are not.
The authority may say that for this examination you are debarred.
Yes.
You are preempting. No. Why they should be permitted to sit in the examination? Why the result should be declared? I am going to punish him for all time to come.
No, we are not preempting that. We are not in a position to proceed with the so cause notice. We are not in a position.
Why you are not in a position?
Because the Honorable Single Judge has already held that if they are not involved in the leakage of question paper, that should be dropped.
That
should be dropped. And if it is to be dropped, then how can we proceed? That is the whole.
I do not know. Sorry.
Only 2 lines have been placed.
I do not intend to make any comment.
Yes.
If this is the perception of the order, then I have nothing.
That is the. Let me place.
Please read.
Let me place only small paragraph.
Yes, read carefully.
In the event, it is found that the petitioners are.
What is the meaning of the word in the event?
That is the order of the court.
I am asking. The
the
English word is used.
Yes.
What is the meaning of the word in the event? And then the if is used.
If ultimately it is found by the.
That means that the court has not said that they are exonerated. The court has said that yes, the investigation must complete.
Yes.
And during the investigation, if the investigating officer found him guilty, then steps against them will be taken. If the investigating officer does not find him guilty,
they automatically
to be exonerated. So you have taken it that the single bench has already formed an opinion that they are not guilty.
Now, prior to that, the Honorable Court has done two things. The aforesaid affidavit file, prima facie, the inference is there, the occurrence took place in two parts. Firstly, the question paper was leaked. Second, the leaked question paper. Prior to that paragraph 10, the Honorable Single Judge has held that matter involves two things. One is leakage of question paper, another getting access to the question paper. Our so-called notice is getting access to the question paper. The Lord Single Judge said, if we don't have any connection with the leakage of question paper, then it is to be dropped. That is the difficulty. We are unable to proceed with the matter. So with regard to, if we ultimately we found that they are involved in getting access to the question paper, then also we cannot take any action. Only that clarification to me.
I do not know, sir. Can you read for me? Because my understanding of the language is very poor. Let us read it, sir.
The paragraph 6. From paragraph 6 onwards, I will read it.
Paragraph 6.
Paragraph 6, page 167. That on inquiry, the IO has come to a conclusion that petitioners who were candidates for junior engineer civil examination were
Paragraph 6.
Page 167. Page 167.
No, you are reading from the impugned judgment. Can you give me the internal page or the paragraph of the judgment, because the judgment
internal page is 3, running page is 167.
Internal
Please, paragraph 6.
Paragraph 6.
It starts after publication of the final.
No, on inquiry. On inquiry.
No.
On inquiry.
What is reading? I am on a impugned judgment, sir.
Impugned judgment is at page. Impugned judgment starts at page 166.
Please, I am at the impugned judgment. Show me
that is a 6.
That what has been said, distinction or no distinction. Please tell us. This is the order which is under challenge.
Is dated
yes, please.
3/2024. Internal page 3, 167 running page.
Paragraph
6. On inquiry.
Yes.
On inquiry, I was come to a conclusion that the petitioners who were candidates of junior engineer civil examination were allured by the accused persons to receive the leaked question papers.
Sorry.
He further stated that petitioners, out of their desperation, have gone to Talsari Baleshwar to receive the leaked question papers from the accused persons. However, a close scrutiny of the affidavit filed by the IO does specific role played by any of the present petitioners so far as leakage of question paper is concerned. Nevertheless, the IO has stated that the investigation is continuing and more materials have been collected against the accused persons. The aforesaid affidavit filed by IO gives a prima facie inference that the occurrence took place in two parts. Firstly, the question paper were leaked. Second, the leaked question papers were sold to aspiring candidates. The petitioners who were the aspiring candidates in this case were desperate to get the job. They were allured by the accused persons. Accordingly, they went to the spot as directed by the accused persons. While they were meeting with the accused persons, the petitioners as well as the accused persons were apprehended from the spot red-handed by the police. Although the petitioners were successfully apprehended at the spot, police led the petitioners to go thereby, giving them an opportunity to appear in the examination, which was scheduled to take place on the next day. It is also a fact that the examination, which was conducted on 16/7/2023, was subsequently cancelled on the basis of the allegation of leakage of question paper of the said examination. Pursuant to the order by this court, the petitioners were allowed to participate in the examination, which was conducted on 3/9/2023. On careful examination of the affidavit filed by the IO, this court is of the prima facie view that the petitioners were party to second part of occurrence. Second part means access to the question paper.
Sir, I understand.
Therefore, it is observed that they were not parties to the leakage of question paper, which is the main allegation in the present writ application. Moreover, the possibility of victimization of petitioners who were by the accused persons with a prospect to receiving the leaked question paper in exchange of some amount of money cannot be ruled out. In the aforesaid backdrop, factual backdrop, this court permits the IO to continue the investigation with the direction to conclude the same as expeditiously as possible by covering all angles of conspiracy. This is important. Further, this court also directs the Staff Selection Commission to finalize the proceeding initiated by issuing show cause notice to the petitioners, to which the petitioners have already filed their reply. In the event that the petitioners are in no way involved in the leakage of question paper, previously they said they are not involved. Now they say in case they are not involved in the leakage of question papers, then such proceeding be dropped, and the result of the examination, which was held on 3/9/23, in respect of the present petitioners, be published within 6 weeks from the date of communication of the copy of the order. Furthermore, in the event it is found that the petitioners have come out successful in the written examination and the proceedings against them are dropped as directed herein above, then the Selection Commission will proceed with the matter for publication of their final result by taking necessary and consequential steps to conclude the recruitment process in respect of those petitioners. Consequently, it is found that if the petitioners are finally selected, then the pendency of the criminal case shall not stand in the way of the petitioners for being considered for appointment to the post of junior engineer civil. That is the part. Ultimately, it is
Fetter under Rule 18. I do not find.
Ultimately, it is held.
There is no fetter under Rule 18. It does not really restrict only for access. It is so wide. Why you cannot take a steps against him?
We can't, because it is ultimately held. If they are not found guilty, their results will be declared. If it is held, in the event it is found that the petitioner was no way involved in the leakage of question paper, then such proceeding be dropped.
Yes.
With regard to second part, nothing has been stated.
Yes.
So ultimately, the beginning it is held, they are not involved in the leakage of question paper, and they say another. Also, focus notice. What is your focus notice?
We'll consider. We got you. You will dispose of the main matter. Sure. You come ready.
Only one page for
next week.
Next page.
Tuesday we can't say. Yes. It's one or two matters every day from the next one. Left out.
I don't 42 of the documents are the credit for there, nothing more. It's a 16 years girl,
Yes.